May please, Your Worship. I
Yes.
beg to withdraw item number 14 with the liberty to file express because some new development has cropped up.
14 and the prayer of Mr. R. Dhar, learned counsel for the petitioner. With petition stands with disposed as withdrawn with liberty to file afresh.
But I beg to mention item number 26 and 27, Malad.
Hmm.
And in this case, Malad, the Malad senior counsel, Mr. P.G. Kaur, was engaged newly, Malad. This matter may be taken up after 2 weeks, Malad. Let it be taken up, Malad, 24 of March.
We submitted at the bar that the petitioners have engaged a senior counsel to conduct the matter. And therefore, prayer for adjournment has been made. In view of above, matter stands adjourned. To be listed again on 24th March.
May I please? Worship, I beg to mention one listing of one admission item, Worship, regarding pension matter, Worship.
Admission, you approach the registry.
Lordship, I beg to mention item numbers 36 to 39, Lordship. But you have taken concern of the other side, Lordship. I beg for an adjournment.
Why do you want adjournment?
Lordship, we'll find an affidavit during the course of the day, Lordship.
You are for the education.
Yes, Lordship, for this
Okay.
education part. Lordship.
On the request made by Ms. R. Barua, learned standing counsel, second education department, and not objected to by the other side, matter stands adjourned. To enable the respondents to file their counter affidavit, list the matter again. On 9th April.
They have some urgency, Lordship, the other side, Lordship. Council for the other.
What affidavit is required, isn't it?
Lordship, if it can fix in the month of March, Lordship.
Any date, any inconvenient date? Hmm.
26/3.
Yes, 26/3. In which case? Interim court order passed earlier, if any, stands extended till the next date of listing.
May, Mr. Lordship, my lord, I beg to mention item number 28 on with due consent from the petitioner, my lord. I pray for the adjournment for a day on behalf of D. Gogoi. I represent respondent number 3 and 4.
Okay, and the prayer made on behalf of Mr. D. Gogoi, learned counsel for respondent numbers 3 and 4. And not objected to by the other side, matter stands adjourned for the day.
On second with the urgent matter.
Any date?
16.
List on 16 March.
Oh, black.
May-
May I please your Lordship? Lordship, I beg to mention item number 23.
What do you want?
Years out of state.
Who is he? Who's your senior? Who's your senior?
H.N. Lashkar.
But there are other councils also. B. Ahmed, N. Haq, K. Uddin. All of them are out. All the 4 councils are out of station. Where have they gone? It is submitted that the conducting counsel, Mr. N.H. Laskar, learned counsel, is out of station and therefore matter may be adjourned for a week. Staff has paid for matter stands adjourned for a week.
May it please your Lordship. I beg to mention item number 43 million. I have been concerned with the other side. I am appearing on behalf of Mr. G. Deka, your Lord. And this matter may be taken up after 2 weeks.
G. Deka is not there.
Lord.
Name of G. Deka is not there in the cost list. Who is he appearing for?
Gita to Deka. The petitioner, your Lord.
You don't have a cost list.
Actually, we.
Hmm.
G. Pathak, sorry. No, last moment he is informed me, so he is out of session, that is why.
So you have made Mr. Pathak as Deka.
Yes.
Is it same? Deka and Pathak?
No, almost.
Then
He is saying.
on the request made on behalf of Mr. G. Pathak, learned counsel for the petitioners. Matter stands adjourned for a week. Yes, next.
Thank you.
My lord, I may be allowed to move an urgent motion on my lord, 2nd of March, my lord. This is then filed day before yesterday. This relating to examination of the petitioner's term that will be scheduled on 7th, my lord. So because it 3rd and 4th is a holiday, so it is a very urgent, matter.
No,
Monday, my lord.
we'll have a 9th
My lord,
March.
my lord, the examination on 7th, my lord. That is why I prayed, my lord, on
No,
2nd.
what is your grievance?
My lord, the petitioner's son is going to appear the exam of this board from 9 to 10. But there is a, my lord, every possibility that he may not be allowed to appear the examination. my
Why?
lord. But there is a certain, my lord, the dispute which arises between the, my lord, the parents of the child. So, my lord, some police case is going on. So we have, my lord, seek the protection of the police. So he may be at least allowed to appear the examination. My lord, there another, my lord, CWC also involved in this case. So I, my lord, pray that that may be taken on 2nd of March, my lord.
2nd, not possible. We'll have it on 5th.
My lord, examination on 7th, my lord. That is why.
Ah, that's why 5th?
Fifth.
Yes.
May it please, Lord. No, we have filed an interlocutory application for vacation status quo order, madam,
Hmm.
regarding a promotion. May I pray that madam will be taken up next week, madam. It's an interlocutory application, madam.
Status quo
Status quo order.
for vacation of that.
Yes, madam.
When did you file the application?
We have filed it. It is numbered, madam. Last week we have filed, madam.
This is also 5th.
5th, madam. Obliged.
Lordship, in item number 37 and 39, there is interim order, Lordship, which is just mentioned by the department.
37 to 39.
37 to 39.
You write one more line. Interim order passed earlier, if any, stands extended till the next date of listing.
With the consent of other side, I would like to get to mention item 22.
What do you want?
Lordship, I am appearing on behalf of M. Hussain, Lordship. He instructed me, Lordship, let the matter will come after 2 weeks.
On the request made on behalf of Mr. M. Hussain, learned counsel for the petitioners, matter stands adjourned for 2 weeks.
May I plead on it? And my lord, I have filed, my lord, one big urgent inquisition last, my lord, 23, my lord, 23 February, my lord, but it is not listed, though it is already reported, my lord. This matter is, therefore.
What is the urgency?
Urgency,
Tell us.
my lord, your lordship directed the authority to reinstate me, my lord. They, my lord, reinstate me, my lord, but in the same order, my lord, they also cut, my lord, my increment, my lord.
No, there's no urgency on that.
Therefore, my
It will be
lord,
listed in due course, 9th of March. Next,
my lord,
nothing will happen, 9th of March. Next,
May I please your lordship? Lordship, with regards to item number 30, we need 2 weeks of time to file the reply.
30 means 30.
30,
How much time?
2 weeks.
Okay, as paid for, 3 weeks time is granted to the petitioners to file rejoinder affidavit to the affidavit in opposition filed by the respondents. List again after 3 weeks.
Item 1 promotion.
Lordship, in this case, Lordship, I would like to keep pending because some area amount of already paid as per the instruction. Regarding non-compliance of that part, only area payment. Other payment monthly salary, monthly aforesaid pensionary benefit is given, but the area, some area part has already been given. So I'd like to keep pending for some days. This.
Like to keep pending. What kind of case is this?
Lordship, this is a
This is to scare the other side that I have filed contempt. If you don't give me the balance, I will move it.
then
No, this is not the way, Mr. Counsel.
No,
If you
Lordship,
file it, you move it
yes, Lordship, then notice may
or
be-
you withdraw it.
because after filing this, Lordship, some area payment has already made. That is why, Lordship.
So what do you want to do?
Then notice may be issued.
Part, Mr.
Is that?
Is it Ahmed, learned counsel for the petitioner, who submits that the order dated 9/6/2025 passed by this court in WPC number 4429 of 2024 has not been complied with by the respondent. Stop. He, however, submits that after the filing of the writ, after the filing of the contempt petition, Part payment has been made, but not in full, as was directed by this court. In view of above, issue notice, returnable by 4 weeks. Steps within 3 days by the speed post. List again after 4 weeks.
Item two.
May I please your lordship? Lordship, this content matter is a non-compliance of the order dated 10/4/2025. The order copy is on Annexer 1, page 9, your lordship. And the operative part is paragraph 12 and 13. And the forwarding is Annexer 2, page 50, dated 19/9/2025.
Your good name?
A. Sharma.
Part Miss A. Sharma, learned counsel for the petitioner, who submits that the order dated 10/4/2025 passed by this court in WPC number 2055 of 2025 has not been complied with by the respondent, despite a copy of the same having been furnished to her. Issue notice, returnable by 4 weeks. Petitioner to take steps for service of notice upon the respondent by speed post within 3 days. List again after 4 weeks.
Item three.
Lordship, in this case, Lordship, we have received that Parawas comment and instruction also, Lordship. We would like to file a short affidavit.
Still in the motion stage.
Yes, Lordship.
You want it to be in the motion stage only? Or should we issue notice? Let notice go.
File the affidavit, lordship.
Lordship, may issue notice, in the meantime, we will file affidavit. Parawas comment issue, Lordship.
Heard Miss
D. Pujari.
D. Bor Pujari, learned counsel for the petitioner. Who submits that by filing this writ petition, the petitioner seeks for a direction to the respondent authorities concerned to release the area salaries, pension, family pension, and all other pensionary benefits to the petitioner, who is the wife of our deceased husband, who was working as an assistant teacher, science, in Majakhali High School, Dahela. Next para, Mr. P.P. Datta, learned counsel appearing for the Secondary Education Department, submits that he has received parawise comments and he may be given some time to file the counter affidavit. In view of above, issue notice of motion returnable by 3 weeks. Mr. P.P. Datta accepts notice on behalf of respondent number 1, 2, 3.
Lordship.
And your good name? Ms. R. Datta accepts notice on behalf of respondent number 6. Ms. K. Pukan, learned government advocate, accepts notice on behalf of respondent number 5. Where is R.M. Barua? Finance. She has come? Please inform her. We'll record her name, Ms. R.M. Barua. SC Finance accepts notice on behalf of respondent number 7. Petitioner to take steps for service of notice upon respondent number 4 by speed post. Headmaster, you can appear otherwise. Headmaster,
No, Lordship, headmaster, let notice go.
speed post within 3 days. Petitioner to furnish extra copies of the writ petition to the learned counsels appearing for the respondent within 2 days. List again on so and so. 8 April.
Item four.
May I please, your lordship?
Yes.
We are teacher in elementary, provincialized elementary educational institutions. So we have been, our services has been provincialized on 5/2/2021. In this writ petition, we are seeking that is equal pay for equal work, my lordship, because our the judgment we have referred Mohan Ali Sheikh versus State of Assam, reported in 2024 5 This,
Before that, you just tell me your status.
yes, my lord.
How many petitions are there?
My lordship, there are six petitioners.
Yes. And who are you and what is your present status?
My lordship, we have, our services has been provincialized, we have annexed the document, my lordship.
You are appointed as what?
We,
Appointed as?
we are assistant teachers, our services were on, in venture, venture institutions, my lordship.
Tutor as a.
And subsequently, as per Assam Reorganization Act, Provincialization and New Reorganization Act, my lordship, our services has been provincialized. And that provincialization order also we have annexed, and we have completed DLED also,
Provincialized as what? Tutor?
tutor, my lordship.
And what is your prayer?
That our salary, we are now getting fixed pay salary, my lordship.
Fixed pay salary.
Uh,
You want scale pay?
Yes, my scale pay, my lordship. Initially, it was 10,800 and subsequently it has been enhanced to 12,000, my lordship. And we have not.
You are the teachers of a venture school,
Yes, my lordship.
correct?
Yes.
Then the school has been provincialized.
Yes, my lordship.
Your service also has been
Yes,
provincialized,
my lordship.
but you are provincialized as tutor,
Tutor, my lordship.
but you're getting fixed pay.
Fixed pay.
Your
Then
prayer
what-
is that you should get scale pay.
Yes, my lordship. That is the.
And you are relying upon Mohar Ali Sheikh's
Yes, my
judgment.
lordship. Yes.
Yes, Mr. Bora?
Let them file separate affidavit before that, in the light of my judgment, my Mohar Ali authority will decide.
What was the judgment? What did the court say?
Court says that
Do you have a copy of the judgment, Mohar Ali?
Yes.
You have enclosed, annexed it or not?
No, my lordship, I have that. Not.
Huh? You have not annexed it. Tell me what was said in Mohar Ali by this court? You have a copy?
This,
You have brought the entire book. You should give me a copy of the judgment so that we can dispose it of.
this one. My lordship, 5 minutes, I will.
Do you know the relevant paragraph? What is the relevant paragraph? Just point out just now. Mr. Bora, we can dispose it off in line with that judgment. You just go through which paragraph is the relevant thing.
Fine.
Please write, hard Mr.
SB Laskar.
Sorry,
SB Laskar.
SB Laskar, learned counsel for the petitioners, and Mr. P.K. Bora, learned standing counsel. Elementary Education Department. Anybody else?
Finance is there. Finance is there and headmaster is also there. There.
Stop. Having regard to the nature of grievance projected by the petitioner, the writ petition is taken up for disposal at this stage. Next para. It is the case of the petitioners. You have to put S, okay? Petitioners. It is the case of the petitioners that they are tutors and serving in provincialized elementary educational institutions under the Elementary Education Department, Government of Assam. Stop. Their services were provincialized on 5/2/2021 under the provisions of the Assam Education, open bracket, provincialization of services of teachers and reorganization of educational institutions, close bracket, Act, 2017. Stop. After their provincialization, the petitioner were given fixed salary of rupees 10,800 per month, which was later enhanced to rupees 12,000 per month. Stop. It is the case of the petitioners that since they are performing similar nature of duties as those teachers who are given scale pay, comma, they should also be given scale of pay as their monthly remuneration. Stop. In this connection, learned counsel for the petitioner has relied upon the judgment of, this is what, DB or single bench? Single bench,
Division.
Division bench, my lordship.
division bench of this court,
Para 1349.
rendered in Mohar Ali Sheikh versus State of Assam, reported in 2024, 5 GLT 698. Para?
Para, my lordship, 175 and 179, my lordship,
Give me the book.
stated in the petition, para 13 and 14. There are 175 and 179.
Mr. Bora,
My lord,
you were talking about some representation.
well, there is no clause of representation because of 6 months has already passed from the passing of the judgment. Man. That
Ah.
is the- There are 6 months time was granted. Man. There are 179
6-month time was granted for?
for taking the decision by the government.
So any decision has been taken?
Not yet, to my knowledge, my lord, not yet. My lord.
Okay. But this judgment is still stands as on
My lord,
today.
true, my lord.
I have perused the authority relied upon by the learned counsel for the petitioners, more particularly paragraph number 135 and paragraph number 179. So the division bench of this court was of the view that by following the equality clause envisaged in Article 14 of the Constitution of India, respondent authorities should extend pay scale to the tutors as considered fit by the state government. And for which the state government was directed to initiate necessary steps in the light of the observation made in the judgment as expeditious as possible and preferably within a period of 6 months. Full stop. It is therefore seen that the case of the petitioners, who are also tutors and enjoying only fixed pay, is squarely covered by the said decision. Stop. Accordingly, the writ petition is disposed of with a direction to the respondent authorities to extend the benefit of scale of pay to the petitioners in terms of the decision already rendered in Mohar Ali Sheikh, Supra. Stop. If benefit has already been extended to the petitioners in Mohar Ali Sheikh, Supra, same should be also extended to the petitioners in the instant case. And if such consideration has not culminated as of now, the state respondents are given how much time? Morali Sheikh has not been, how much time should we give you?
3 months.
3 months time
If
from
they
the
are
date of
entitled-
receipt of the certified copy of this order.
If they are entered after verification of the.
Subject to verification and the entitlement of the petitioner. All right.
I have read my lord.
Item 5.
Lawsuit, with regard to the lawsuit typographical error also, I have filed an application also. That's come along with the.
Where is that? What is it? What is the error? What is the error?
Error lawsuit at in lawsuit, para 11, page 111. These 3 lines has kept in to delete this, page 5, para 3 lawsuit. The inspector of school corporate by notification that so and so. This pertaining to some other case lawsuit. It was inadvertently kept in lawsuit. And lawsuit, page 6, this prayer portion, the annexer I have corrected lawsuit. The 2016, the last notification lawsuit, it is not connected.
Just a minute. Can you simplify it? What is the error? From where you'll point out the error? From the writ petition or from the IA?
On the IL also.
From the IA.
In
So
the,
what-
in the writ petition, page 111 lawsuit,
111. Let us see.
page 11.
111.
Page 11 lawsuit.
Oh,
Page 11 of the writ petition lawsuit.
yes. Which part?
Lawsuit.
Which part?
The last 4 lines of the paragraph 11 lawsuit. The inspector of schools board by notification letter. This is relevant. This is not relevant with the present case lawsuit. So these 4 lines may be deleted lawsuit.
Starting from the.
Starting from the inspector of schools board by notification dated
Uh-huh.
16 to 2026 has invited 54 teachers. These 4 lines should be lawsuit.
These 4 lines.
Lawsuit.
Whether it is the final list, this much.
Lawsuit.
Okay. Then
Then lawsuit in the in my lawsuit prior lawsuit. In my prior lawsuit, that last annexure lawsuit 16 to 2026. That is not relevant, and we have also not annexed lawsuit. That is pertaining to some
prayer portion, which page? Page number
page 16 lawsuit of the writ petition.
16.
Lawsuit. First paragraph.
Ah,
That last paragraph, the 16 to 2026. Notification lawsuit is not relevant lawsuit.
16 to 2006, annexure 7.
16 to 2026.
You want to delete
Annexure
this?
7. Yes, I want to delete it.
Anything else?
And also in the paragraph 18 also lawsuit that annexure we have renumbered also.
Just a minute.
Annex interim prayer annexure 18 page 18 also. The last annexure 16 to 2026.
Page 18.
Page 18 also.
Which portion?
The last one also.
Which one? Which one?
16 to 2026. Para 8. It starts from page 17.
Hmm.
That's 16 to 2026. Also. And I have given lawsuit what it were corrected in my IL also.
So correction required is prayer portion, page 18. Then page 16 also,
16 also.
and page 11
Page 11.
in 3 places. Now, if you replace this, the page number will change, isn't it?
No, lawsuit. I have already prepared the amended cost title lawsuit. We have kept it intact also.
No, supposing page 11
Lawsuit.
of the writ petition,
Lawsuit.
you want to delete as many as 4 lines.
4 lines.
So if you delete 4 lines from page 11,
Lordship.
so 4 lines from page 12 will come up to page 11.
No, Lordship, we have prepared Lordship.
No,
Lordship.
amended petition of planning board.
Lordship, we have already prepared the cost title also, Lordship. Lordship can say, Lordship. The page number is intact.
It will be better.
Huh?
An amended petition has to be filed in this case. Otherwise, there will be any confusion at all. Because
Lordship, my learned friend is again complicating the issue, Lordship. Lordship, I have already prepared the.
No,
prepared
no,
the
not,
amended
he is
cost
not
title.
complicating. You are complicating.
otherwise, it is.
You are the one who's complicating it.
Lordship, that.
See, in ordinarily, what you should do is that you say that there's some mistake here. Let me withdraw and file afresh. Matter ends there. Now you want to specifically take out few lines from here, this page, 1 line from this page, 1 line from this page.
Lordship, I have already prepared the amended cost title. Also, may kindly have a page. The page number is.
Why should I look into that?
Page is same, Lordship. Page 11 will be there. Only the 4 lines will be deleted also. There will be intact page number.
See, we'll allow you this, we'll allow this IA, you file an amended writ petition. Not just replace that page only. Because there might be some discrepancy in the page numbers later on.
The entire repetition.
Yeah?
Lordship.
Any difficulty on that?
No.
It's better that way.
Or we can also, the amended post title also, the page number is intact also. Lordship, may kindly have a page also. I have sent the page three pages also.
See, even before allowing the amended thing, why do you want me to see something which you have drafted?
That is.
Hmm?
All Lordship.
Then what about the cost title? Cost title also will have to be changed.
Post title is correct also.
Where
16 to 2026, that is not there in the cost title.
It is not there.
It is not there.
It is not there.
Are you sure?
Yes.
So what requires correction? Let me repeat again.
Lordship. Only
Is
respect of page number 11. That
Page 11,
page 11.
then
And Lordship, the in the
page 16
16 and 18.
and page 18. Hmm. See, page 16 and 18,
Lordship.
perhaps the original page number can be retained.
Lordship.
Because deletion is not much.
Lordship.
But in respect of page 11,
Lordship.
deletion is at as many as 4 lines.
Lordship, see, it's page 11. I have kept intact also.
Okay. Heard, Mr.
SK Das.
SK Das, Learned Counsel for the petitioner. Public applicant who submits that by filing this application, the applicant seeks deletion of certain unwanted lines in the writ petition, which inadvertently has been added. Also, no, although the same has no bearing in the writ petition. Stop. The Learned Counsel has drawn the attention of this court to the statements made in paragraph number 12 of the writ petition. And submits that the last sentence of paragraph number 11 is not necessary and should be deleted. Stop. He further submits that notification dated 16/2 to 2026 bracket annexure 7 mentioned in prayer A of the writ petition, A within small a within bracket at page 16, and notification dated 16/2/2026, bracket annexure 8, mentioned in the prayer portion at page 18 of the writ petition should also be deleted. Stop. Mr. P.P. Datta, learned standing counsel. What is this? Elementary, secondary education. Submits that he has no objection if the amendment is allowed. That's paid for. Stop. In view of above, the application for amendment as paid for in the application is hereby allowed. IA stands disposed of. Main writ petition, you write. In view of the order passed today in IAC number 625 of 2026, the petitioner, how many? More than one? The
Four.
petitioners. The petitioners are allowed to replace page number 11, 16, and 18 of the writ petition by submitting the amended pages in 2 sets before the registry. Stop. Before the registry, within,
Lordship, today itself, Lordship, within 1 hour, Lordship.
don't say that, within the course of the day.
Also.
Stop. Once the amended pages are submitted, registry shall replace them. Registry shall do the needful for replacing them. Stop. Notice has not gone, isn't it?
No.
You supply the amended cost title. So you give an advance copy, isn't it?
Lordship,
List the matter when?
also on Monday, Lordship.
Monday.
Apply.
Give a date. 9. Oh, 2/3, sorry. 2/3.
May I pray, Your Lordship? The petitioner here is appointed as additional teacher on contractual basis in 2010. He had been serving in the same school from 2010. In 2015, Lordship, his post was regularized in the same school and he had joined as regular graduate teacher. But unfortunately, when the headmaster retired due to superannuation, the director of secondary education appointed a junior person as in charge principal of the same school. He was 3 years younger than him, denying the petitioner his seniority, Lordship. The private respondent has joined already in this.
What is the name of the school?
Mori Jaji, Lordship. Mori Jaji Sesa Patra HE School.
What is your designation?
I was first appointed as an additional teacher, Lordship.
Now
Now regular graduate teacher, Lordship.
you are a graduate teacher.
Oh,
Teaching what? Economics.
sir, Lordship.
What are you teaching? What are you teaching?
Lordship, that
What subject? Your grievance is basically that you should be the in-charge
Research
principal
principal was.
instead of the private respondent.
Yes,
On
he was
what-
younger to me.
On what basis?
He was
Seniority?
appointed 3 years earlier, later lordship. In 2013, he was appointed. On contractual basis also. Lordship.
Heard, Mr.
UP Chaliya lordship.
UP Chaliha, learned counsel for the petitioner, who submits that the petitioner is agreed with the appointment of the respondent number 5 as the in-charge principal of Mori Jhanji,
Morishasi,
Mori Jhanji,
Sesa,
Sesa Satra.
HE
HE means what? HE means
was a higher education.
higher education school. That is the name of the school.
Yes, lordship. HE school.
Mori Jhanji, Sesa Satra HE school. Despite the fact that respondent number 5 is 3 years junior to the petitioner. So the petitioner therefore seeks interference of this court to the order dated 19/9/2025, passed by the Director of Secondary Education, Government of Assam. The learned counsel submits that pursuant to the said order, the respondent number 5 has already joined as such. Next, para issue notice of motion returnable by 4 weeks. Mr. T.P. Datta, learned signing counsel, Secondary Education, accepts notice on behalf of respondent numbers 2, 3, and 4. Ms. K. Fukan, learned government advocate, accepts notice on behalf of respondent number 1. Extra copies be furnished to them within 2 days. Petitioner to take steps for service of notice upon respondent number 5 by speed post within 3 days. List again after 4 weeks. Before bench street.
May it please your lordship, this is regarding appointment and selection of Anganwadi worker. My lord.
So somehow it has come to this court. Bench tree matter, isn't it? It is submitted at the bar that the matter is a bench tree matter. Registry to verify and list accordingly before the appropriate bench.
Item 8.
May I, my lord, I am a family pensioner, my lord, getting pension since 2000, my lord. But due to non-submission of the life certificate, my lord, in the year 2019, my lord, October 2019, I could not submit the life certificate. And as such, my lord, my pension was stopped, my lord. Thereafter, my lord.
October 2019.
Yes, my lord.
Okay. Then thereafter?
Thereafter, I have submitted life certificate and other things, my lord, representations were submitted, my lord. But after, my lord, as per treasury rules, if the pension is stopped for 1 year, then it should be revalidated by the pensioning authority, my lord. So pensioning authority is the director of pension. So revalidation is required, my lord. And therefore, my lord, page 19, my lord, may be seen.
Did you apply for revalidation?
Yes, my lord. I have applied to the treasury officer also, my lord, submitted letters for revalidation. Page 19, my lord.
Yes.
Annexure 6, my lord. This is the letter by the treasury officer.
Then after that, annexure 7.
Thereafter, my lord, I have also submitted, my lord, representation. Page 22, my lord.
No, 20. What is 20?
20 is also a communication by the director of pension, my lord, to the treasury officer, my lord. So, my lord, they to submit up-to-date royal statement against PPO number so along with statement showing additional arrear pension to be paid. This is the communication between the treasury and director of pension, my lord. But till date, my lord, revalidation is not done, my lord. So I have to approve this honorable government. Only, my lord, rehabilitation is required, my lord. And this is pending, my lord, since January 2025, my lord.
Yes.
So I am for the respondent number 5, Punjab National Bank.
Ah.
So I have no role to say.
They have to revalidate, that's all.
There, yes.
The revalidation has to be done by the pension department.
Pensioning department.
Yes,
Director
Pugan?
of pension.
Huh? What is required? Hmm. Who will go for, who
No,
will
my
give
lord,
the,
AG is not required. It is pension sanctioned by the pension sanctioned by the director of pension, my lord.
just a minute. Then 20. What is this rule 221? How old is the lady? How
My
old
lord,
is she?
She is, my lord, 64 years, my lord, now.
64.
Yes.
And husband was working as?
Yes, Chowkidar, my lord, in a school, my lord.
Hmm. Who's appearing for the pension? You are there for the pension. And who's appearing for AG?
AG is not a party, my lord.
Not a party.
You know,
The thing, my lord, that they, from treasury side, send say, I come to the office, my lord. Can to do, this earlier pension, if you do execution, no?
director of pension.
Don't but.
Not AG. It is the director of pension, my lord.
Annexure 6 says that pension has to be revalidated
Yes, ma'am.
By the pensioning authority.
and written by the treasury officer to the director of pension. Then if specifies that if area exceeds rupees 50,000 or if it being paid for the first time from the approval from the accountant general oblique director of pension is necessary. So director of pension, it can be. AG may not be required. You obtain instructions. We'll list it again on Monday.
No, my lord, not Monday, my lord.
Why?
On 5th or 6th.
Huh? A week. Okay, on 9th. 9th. Please write. The sum and substance of the grievance projected by the petitioner can be seen from the representation submitted by her on 9/7/2025 to the Director of Pension, Government of Assam. Annexed as Annexure 9 to the writ petition. Ms. K. Fukan, learned government advocate, shall obtain instructions. Shall obtain instructions as regards the status of revalidation of the pension. Revalidation of
Family pension.
family pension.
Under PPO number, my lord, that may be mentioned.
Revalidation of the pension of the petitioner. What is your PPO number?
PPO number, my lord, E/FP/ 40812.
Okay. Under PPO number, capital E/FP. P for Punjab, FP /40812
Yes.
by the next date. List again on 9th March 2026. You want an extra copy? An extra copy of the writ petition be furnished to Ms. K. Fukan, learned government advocate, to obtain the instructions. Give her an extra copy.
That my presence may be there.
Oh, yes. Your good name?
Respondent number 5, A Parvez,
Mr. A. Parvez
for respondent number 5,
appears for the, what bank is that?
Punjab National Bank.
Appears for the Punjab National Bank, bracket respondent number 5.
Apply.
Item 9.
On the petitioner before this honorable court, my lord, he is, my lord, is a my lord, peon, my lord. Initially joined in service, my lord, 27/1/92, my lord, as a my lord, night showkeeper, my lord. His appointment letter annexure 1, my lord, page, that is page 14. And original copy is page 14A. Next page. Sajuddin Ahmed is hereby temporarily appointed as grade 4, the employee on casual basis in lump sum pay of rupees 1. Next page is, my lord, annexure 2, 27 January 1992, joining report, my lord.
No, where is that? Which annexure?
Now, my lord, what is happened?
Page number.
Page, my lord, that is page 15, joining report.
You are showing me page 14.
Yes, my lord, 14 initially he joined, appointment letter, my lord.
Appointed as what? Grade 4?
Yes, my lord. Great, my lord. Casual basis, lump sum.
What is the date?
Date, my lord, 27 January 1992.
Yes, then?
Thereafter, my lord, joining report page is 27, on the same day he joined. And my lord, there was some process of regulation, my lord. Accordingly, my lord, this letter, I'm just coming the recent letter, my lord, page, annexure 7, page 26. And annexure 7, page 26.
Yes.
Proposal for regulation of service of workers, master roll, so and so. In inviting reference to the government letter, the subject said, I have the honor to submit here a list of casual employee along with copies of proposal and other documents received from the different inspector of the School of Assam for regulation of the services who were engaged prior to 1/4/93. And his name in the next page, page 27, at serial number 17. Sajuddin Ahmed, that of the night showkeeper. Now, as there was a move, my lord, from the government of Assam, my lord, prior to 1/4/93, some of those persons, my lord, master roll employee peon were regularized, but the petitioner left out along with some persons, my lord. That's why this letter was issued. And subsequently, my lord, various letters have been issued, my lord. And recent letter 1, my lord, page, annexure 9, page 31. Annexure 9, page 31. The inspector of the school wrote, submission of proposal in respect of Sajuddin Ahmed, casual employee in the office of the inspector of the school. With reference to the subject stated above, I have the honor to submit here with the original documents received from so and so casual employee. Further, I would like to inform you that the Sajuddin Ahmed had been appointed casual employee by the then inspector of the school, order dated so and so 20/11/92 in the office of the undersigned. Therefore, I request your honor be kind enough to regularize the post as grade 4 employee in the office of the inspector of the school. And without having any response from the authority, my lord, he filed one repetition before this honorable court, my lord. In the year, my lord, 2023, and that repetition was disposed of in terms of the order of the, my lord, division bench, my lord, Upen Das. That is also annexed by me, my lord. Page 33. That's from relevant portion is, my lord.
Why Upen Das?
Upen Das, my lord, at that relevant point of time, it was followed, my lord.
No, you are seeking regularization.
Yes, my lord, but in spite of that.
Upen Das is only for pay.
Yes, my lord, that was, my lord, mentioned wrongly, my lord.
Where?
But in that judgment, possibly at the time of argument of the case, as it was mentioned, page 33, the honorable court of mentioned here the Upen Das, others, etc., and representation has to dispose of only. That was the order. Some representation has to dispose of within a period of 90 days. That was given, but as it was not disposed of, our time was over. Again, he petitioner extended the time period to submit representation and dispose of this matter, my lord. 5th July, it was extended. But what is happened, my lord, next page 38. Annexure 12. Page. Hearing was conducted. Statement in hearing held on 11/9/23. Lordship, page 38. With reference to the subject cited, I have the honor to submit here with written statement on the hearing held on so and so in connection with WBC case number so and so. That Sajuddin Ahmed was appointed. So and so same fact mentioned. 92 he was appointed. 370 was initially paid. Now it is given 9,200 only with effect from 18. Up till now, respectively, through the Treasury Office, Golpara. During the period service, Sajuddin has extended his service to the satisfaction of the officers, so and so. But
Mr. Das, what is your grievance?
my grievance is, my lord, that for regulation of his service, my lord.
Not pay.
Yes, my lord. And this salary has been stopped. Because from the month of May 25, it has been stopped.
Why?
Because, my lord, possibly, my lord, this Upen Das judgment, there was to release the salary, but I am praying for regulation of service. The one letter was issued to the petitioner, my lord, that you need no, he cannot claim for regulation. Undertaking has to be given. Whereas I did not sign, dear my lord, they have stopped my salary from the month of May 25, and this is fully covered case, my lord. Pradip Chakraborty's case, my lord. Paragraph it was left out employee 1493. Honorable. This court, my lord, just dispose of this case. Just, your lordship, at a glance, last paragraph, your lordship, see, 63 mark, dear my lord. Those are the employee who, my lord, left out in prior to 1493 work, my lord, started their works. They has to be considered. Last case. Yes, my lord. It is judgment cover. It will 14 jail. Pradip Chakraborty. Because let the notice may go, my lord, and mentioning this judgment is covered case, and my lord, this salary may be processed, my lord. Otherwise, family, I am in deplorable position, my lord.
Lordship, let notice go. I have not about page 34, Lordship.
34.
That's I want to point out.
Yes.
However, on being inquired, Mr. Ahmed, learned counsel of petition on instruction submitted that the petitioner is not pressing the pair for regulation of service.
No, that was earlier case.
So that's it is his submission, Lordship, in earlier round of the petition. Now, how can he claim that regulation in this petition?
No, if I pray, my lord, then I cannot be able to get the Upen Das salary also, my lord. They both have already stopped, my lord. So I am in the better footing of this judgment, my lord. Upen Das has been already modified, my lord. Upen Das judgment modified, my lord.
That is, my lord, Dharam Singh judgment has come, my lord.
Whatever may be that, it is his undertaking that he will not pay for
That is
regularization.
earlier judgment and it has been already.
That judgment, that order has not been reviewed till today, Lordship.
Like Sukida, I'm working, my lord,
Oh.
9,200 salary, that has also been stopped. It is full ban judgment, my lord, all everything, my lord, covered here. This Upendas may not come, my lord. Prem Singh also was there, my lord.
Review রাখলে file নেই।
Review না লাগে। এটা আপন কেস না, তেইশ
এই review করুন।
আর এই Dharam Singh তো নাই কিন্তু। review এই Upendas।
তুমি নিজে না লাগে, উপেন্দ্র বাদ দিও না, তুমি নিজে review রাখলে ঠিক হয় না।
Judgment after
Your synopsis says that salary has not been paid.
Yes, my lord. Salary stopped from the month of May
No,
25.
before you say yes, listen to the entire sentence also. According to you, you said because of non-renewal of the financial concurrence. Why it was not renewed? It is not that just
Yes.
because you have not signed something
Yes,
that
my
you have not given salary.
Yes, my lord.
They have not renewed. The concurrence of the finance is not renewed. So how do you expect to get the salary?
Yes, my lord. That is, my lord, they are not renewing because, my lord, not regularizing also undertaking. I have not signed the undertaking.
Where is the statement? Have you made a statement like that? Because I have not signed, they are not giving me money.
Yes, miss.
Where is that?
Paragraph 7, Lordship, he has stated in page 9.
Regulation,
Eight and nine.
but the exponent not giving. So you will stop my.
What does it mean?
Want to, oh, yes, of service, which is not. Paragraph 7, page 9. Correction.
Heard Mr. H. Das, learned counsel for the petitioner, who submits that by filing this writ petition, the petitioner has sought for a direction to the respondent authorities to regularize the services of the petitioner as well as pay him the salary, which has been stopped. Since the month of May 2025. Of the learned counsel submits that salary has been stopped since the petitioner has refused to give an undertaking that he will not claim regularization of service. Mr. P.P. Datta, learned standing counsel, secondary education, submits that the petitioner earlier approached this court by filing WPC number 1704 of 2023, which was disposed of on 24/3/2023, wherein it was clearly recorded that the petitioner is not pressing the prayer for regularization of his service. Mr. He therefore submits that despite the same, the petitioner now has sought for regularization, taking a contrary stand. Be that as it may, the notice of motion be issued, returnable by 4 weeks. Mr. P.P. Datta, learned standing counsel. Secondary education accepts notice on behalf of responding numbers
1, 1, 3, 4, 7. 1, 3, 4, 7.
1, 3, and 4. 1, 3, and 4?
And 7.
1, 3, 4, and 7.
Lordship.
Mr. S.K. Mehdi, learned standing counsel, AG Assam, accepts notice on behalf of respondent number 5. And Ms. R.M. Barwa, learned standing counsel, finance, accepts notice on behalf of respondent numbers 2 and 6. Extra copies be furnished to the learned counsels appearing for the respondents. within 2 days. List again. After 4 weeks.
Well, pending disposal salary.
What salary?
Salary has been stopped, my lord. In current also, my lord.
Oh. Learned counsel for the respondents shall obtain instructions as to why the salary of the petition has been stopped by the next date. Give a date, please. List again of 6th April. One more line, please add. The beginning portion. Mr. H. Das, learned counsel, submits that the case of the petitioner is squarely covered by
Subject to undertaking, my lord.
the judgment rendered by coordinate bench of this court in Pradeep Chakraborty and others versus State of Assam and others. 2014 1 GLT 617. And also by the apex court decision in Dharam Singh and others versus TWP and another. 2025 INSC 998. Then in view of above, no issue notice. Yes.
My lord, in undertaking, my lord, salary may be, my lord, please, my lord, please, my lord, subject to any undertaking, my lord. Because he is not surviving, my lord, because of the salary, my lord.
Let them get instructions first.
Yes, yes.
We're
Date
fixing a
is
date.
fixed. That's.
On the next
Yes.
next date, we'll see
Okay.
about
How
salary
will I
part.
Item 7.
May it be pleases your lordship. Here, your lordship, they have challenged the rule, your lordship. It should be go to
What rule?
division bench.
Which rule?
Lordship, we have challenged rule 14.
14-1
Of what?
and 14 of 2018 rules.
The rules is called Assam Secondary Education
Yes, Your
Provincialized Schools Rules 2018.
It is right. The petitioners
Yes.
have challenged Rule 14 bracket 1 and 14 bracket 3 of the Assam Secondary Education open bracket provincialized schools bracket close rules 2018. Where is that rule? It's available here.
Yes.
Page.
Lordship, page 35.
Not 35. Okay,
Okay.
of course.
Yes.
The relevant portion you're saying that. Okay.
Yes.
Why have you challenged this? District-wide seniority.
Yes.
You don't want that district-wide seniority.
So, Lordship, why we have challenged is that
Mm.
as the current list goes on, as per the current rules, a person can be appointed for 6 months also. A person can be appointed for 6 months as a regular
Mm.
headmaster. And
Bench or bench.
Mm.
PB bench.
and there is no weightage given to prior administrative experience. So because Lordship had asked that, that's it.
Your friend is wondering why court is hearing the matter.
Yeah, that's what she's.
I'm just asking out of curiosity, what
Yes.
see, as per these rules,
Yes.
what is the offending part according to you?
Now, Lordship, under 3 legs, I'm challenging. First of all, it says, even if I go by this rule, it says that there should be a district-wise gradation list. And as per the district-wise gradation list, they will go ahead. Now, as on today, they are going ahead with the applications. We are not being called. But district-wise gradation list, as per Rule 25, should be published at the beginning of every calendar year.
Not published.
Not published. So as on today, we don't know where we stand in the gradation list also. That is one thing. Secondly,
Then why should you challenge the rule? Then you can say that publish the seniority list.
now,
That's all.
if that comes in the instruction, now there is another thing. We are from last 2.5 years, we are a headmaster in charge. Now, these rules nowhere has given any weightage to anybody having prior administrative experience. So the rule as it stands today, it can be that a person who had never been a headmaster and even for 6 months, because these are constitutional rules under 309,
So there is no statement of object also. But generally, as I understand, regular headmasters is for continuity in the administrative side of the matters. So there cannot be continuity also. Because a
Alright.
person, because there is no maximum age limit, because in so far as higher secondary principals are concerned, Lordship already knows 57 is the maximum age limit. After that, a person cannot be. So here that is also not there.
Okay. What is the last line? Full stop. The rules have been framed under the proviso of Article 309 of the Constitution of India. And as per the relevant rules of the Gauhati High Court, the same has to be placed before the division bench. For registry to place the matter before the appropriate division bench. Before the appropriate bench for consideration.
I'm deeply.
Obliged.
Oh.
Represents.
Yes.
The matter pertains to my non-payment of area salary of my suspension period. Well, at this stage, I prefer only notice, the instruction.
Non-payment of,
Area salary of my suspension period.
you have been reinstated.
Yes.
By which order?
By order.
Speaking order.
5/10/21.
Annexure F, page 30.
Yes, yes. Page number 30.
Anything about your salary?
Salary, my lord, only, my lord, third paragraph. They cleared, my lord. The charges brought against the INACO assistant professor in the Department of Zoology, Borga College, so and so is misappropriation of fund money of a society named Chonsoy Aru Rindan Somobai Committee Ltd of Borga College, function under the Assam Cooperative Society Act. The society is not under the jurisdiction of Director of Higher Education. There is no link with that, my lord, government, Higher Education Department. So therefore, my lord,
No, any DP pending now?
No, my lord. Only criminal case is pending, my lord. Whenever I visited the office, my lord, they told me that let them finish the criminal case. What is the connection, my lord, in the criminal case?
Yes. Mr.
If there is a question of recovery, then, my lord.
I heard Mr. D. Gogoi, learned counsel for the petitioner, who submits that by filing this writ petition, the petitioner seeks for a direction to the respondent authorities concerned to pay him the area salaries on his reinstatement. After being placed under suspension by its speaking order dated 5/10/2021. Bracket annexure F. Stop. The learned counsel submits that there is no department proceeding pending against the petitioner. And therefore, the respondents may be directed to release the area salary of the petitioner. Text per view of above, issue notice, a motion returnable by 4 weeks. Mr. D. Upamanya, Learned Standing Counsel. This is what higher education accepts notice on behalf of all the respondents. Extra copies will be furnished to you within 2 days. List again after 4 weeks. On so and so, give a date.
But in this case, we have put to challenge the impugn order of rejection, whereby the claim of the petitioner, my lord, for provincialization has been rejected. Page number, my lord, 101.
Second round. Is it the second round?
An
Yes,
extra
yes.
15 your
An
lordship.
extra 15, my lord.
112.
112.
No, my lord, 101.
They have not given the proper copy. Right now, they are.
Ah. So he's waiting for you to make that protest. Only, and then only he'll give.
Yes, sir. This second page, my lord.
Yes.
Lordship will find the selection of the SLC as well as my lord, the DLC as well as SLC has recommended the name of the petitioner, my lord, for provincialization, and it has attained the finality. After attaining the finality, when order was about to pass, my lord, this impugn order has been issued, whereby, my lord, in last paragraph, my lord, it is stated that the petitioner does not fulfill the criteria of 6 years of continuous service, and as such, it cannot be considered.
There is in the rule itself, your.
Where, which portion are you reading?
My lord,
103, your lordship.
the next page, my lord, but meanwhile, paragraph 2, my lord,
Second
page, annex 15,
Yes,
second
yes.
page. But meanwhile, a new fact emerged that the petitioner Srimati Parvati Tekar does not fulfill the criteria laid down under section 423 of the such and such act, my lord, that is, must have rendered at least 6 years continuous service as on such and such date from the date of joining up in the bench education. Now, my question is that, my lord, had there been any loopholes, my lord, it has to be placed before the SLC as well as before the director cannot so much to take a decision which has been already taken by the SLC and DLC and SLC and therefore joint committee in favor of the petitioner. It is against the settled procedure. That is why, my lord, it suffers from procedural lapses.
Now, show me the order by which the writ petition was disposed of earlier.
My lord, it's annexer 10, page 71. Annexer.
Huh? Page
Page, it will be my lord 71, my lord, 71,
71.
annexer 10. This honorable court, my lord, directed for provincializing the, my lord, service of the petitioner as an additional teacher, my lord, in the event the numbers of students are as per the prescribed norms, my lord. And it is admitted by them, my lord, on their recommendation as well as in all the forwardings submitted thereafter, that the petitioner, my lord, fulfills the criteria of to be appointed as additional teacher.
You come to page 73.
Lordship?
73, paragraph 5. Direction is given to the district
Yes,
scrutiny
yes,
committee.
Morrigaon district is directed to examine the service particulars as well as to arrive at the satisfaction as regards the number of students enrolled in the subject in English, such and such school, if the petitioner is otherwise entitled and the number of students are more than 150. Appropriate reason order be passed as to whether the school concerned is entitled to a third post for the purpose of provincialization in the subject English. If yes, consequential benefits accordingly be provided to the petitioner.
Another, your lordship.
Your lordship will
order.
find thereafter at annexure 11B, while submitting the report, and the DLC report has been there, page annexure
See,
11E.
101
Yes, sir.
impugn order, 101,
Yes,
1, 2, 3, 4, fifth paragraph. Inspector of Schools, MDC.
yes. Submitted a copy of the minus of the DLC dated 24th February 2022, recommending the petitioner, Srimati Parvati Tekar, in third post in the subject English in Lahorigarh Senior Secondary School, such and such.
So, district scrutiny committee recommended in your favor.
Yes. Thereafter, SLC and the joint committee has also been also recommended in my favor.
71 page, your lordship. Director in the inquiry shall also look into whether due procedure of law was followed or not. An inquiry before the resolution number 4 was passed or not. Here, your lordship, to verification of documents, your lordship, director is also, your lordship, appropriate authority.
Which page?
Page 71,
Earlier order, my lord.
earlier order.
No, something wrong with the page. Page 71 is annexure 10. First page.
Yes,
Last page.
last page
Which
74.
paragraph? Which paragraph?
Paragraph 6, my lord.
1, 2, 3, 4. Last one, your lordship, 18 onwards, your lordship, 18. The director itself, it the director in the.
That I've not seen. You're reading from which order? I don't know.
আপোনালোকৰ নহয় নেকি?
Similar orders, my
A
lord.
similar order has been made, your lordship.
This
But
is
here,
not
your
relevant.
lordship, director can take your lordship. Because due procedure of law, your lordship.
So you show me, where is that? I've not seen it till now.
Lordship
You
page,
said 71. 71 is just the cost title, WPC 4409 of 21.
lordship page,
So please describe what is that 71? What is that order? Which order? Date, paragraph number, all that? Something wrong with the page number.
বেলেগৰ হ'লেও ক'ব লাগিব ন? Similar কিয় লগাইছে? It's passed by
She is reading from Annexure
20
9, my lord, Annexure 9, paragraph 18. It will be, lordship, page number.
order passed on dated 29/7/2021.
This is a case of Rupanjali Mahanta,
Yes, lordship.
Yes, your
not the present petitioner.
Not the present case.
Heard Mr. D. Prokashta, learned counsel for the petitioner, who submits that the petitioner is aggrieved with the order dated 10/2/2025, bracket annexure 15, passed by the director, by which the prayer for provincialization of the service claimed by the petitioner has been rejected. Learned counsel submits that the director of secondary education, instead of referring the matter before the concerned scrutiny committee, has taken such a call by himself. So therefore, there have been procedural flaw, FLAW, in the impugn order. The same should be set aside. In view of above issued notice of motion returnable by 4 weeks. Ms. P. Das, learned standing counsel, secondary education, accepts notice on behalf of respondent numbers 1,
1, 2, 3, and 4.
1, 2, 3, and 4. Deputy Commissioner also.
Also true. Deputy Commissioner really. Yes, sir.
1, 2, and 4, huh? Then. Who's the GSM?
Yes, something wrong.
Anyone?
1, 2, and 4. GS, sir.
Respondent 3, no.
Petitioner to serve note. You are also standing counsel or GA? Ms. Pukan. Huh? Who? Mr. G. Pegu, learned government advocate, accepts notice of. Learned G. Pegu, learned senior government advocate, accepts notice on behalf of respondent number 3. Extra copies will be furnished to the learned counsels appearing today, within 2 days. Petitioner to take steps for service of notice upon respondent number 4 by speed post within 3 days. List again
Deeply obliged. Damn it, like,
on 10th April.
I'm deeply obliged.
May I please the lordship?
Yes.
So the petitioners were irregular teachers. They were initially in the year 1999, they were appointed. Subsequently, their appointment were held to be irregular. Nevertheless, on to 7/10/2020, the government of Assam has taken a.
What are you challenging?
Yes, my lord.
Straight away tell me that.
And
What are you challenging?
my lord, salary has not been released, my lordship.
What are you challenging?
I'm not, I'm challenging my lordship. They have issued a show cause notice to me.
So you're challenging the show cause.
Yes, yes, my
Page
lord.
number?
Page number, my lordship. Yeah. So cause notice, my lordship. On page number 48, my lordship, and 453. I'm relying on a judgment, my lordship, which I have a.
No, before you rely on a judgment, at least tell us the facts. What is the fact?
This is the show cause notice, my lordship, on page 48.
Why have you been show caused?
They are saying that, my lordship, they could not get my certificate, my lordship, my basic training certificate. And because of that, my salary has not been released, my lordship.
So why can't you produce your basic training
I have
certificate?
submitted my certificates, my lord. They could not get the relevant documents in the SCERT. Director of SCERT has stated that some documents, they cannot locate the document. So similar issues has been raised, my lordship, in earlier writ petitions also, my lordship. The Honorable High Court has stated that mere non-availability of documents they cannot infer that my certificate is wrong or fake, my lordship. Because my lordship, same institution, due to page.
So after show cause, what happened?
After show cause, my lordship, I have submitted my reply, my lordship.
Yes. Where?
On my reply, my lordship.
50.
Yes, my.
Then after that,
After that, nothing had happened, my lordship.
they have not taken a decision.
No, my lordship. That is the grievance, my lordship. And already, my lordship, similarly, they have issued.
Your reply was in the year 2022. Show cause in the year 2021. Nothing has happened. Or what? What has happened? Nothing has happened.
They have not taken decision. At last,
So?
my lord, without finding any alternative opportunity remedy, my lordship, I have come before the court, my lordship.
For what?
Because they have not taken any decision and they have not.
So
given
that's
my
good for
salary.
you. They have not taken a decision.
And they have not given my salary, my lordship. And one judgment, my lordship, Honorable High Court has considered, my lord, similar matter, Honorable High Court has considered. Page 79 may be seen, I have annexed, my lordship.
Salary has been stopped since when?
Salary has not been released, my lordship.
Since when?
Initially, my lordship, in the year 1999, I was appointed and my appointment was held to be irregular, my lordship. So, initially for
Mr. Counsel,
yes, my lord.
you answer the question I'm putting to you.
Yes, my lord.
Don't start narrating story that you were born on that day, so and so, you are from that village. Not required. I'm asking you, since when
My
did you
salary has
get not
been
get salary?
released, my lordship. Because
Since when?
My lord,
You have never got salary in your lifetime.
after accommodation, I have not got, my lordship. My
Since
salary-
when? There must be a date.
Yes, my lordship. I have a date, my lordship. Accommodation letter in 31/2021, my lordship. I have annexed page 40, my lordship. This is the accommodation letter, my lordship.
Page number?
Page number 40, my lordship. Copies of the accommodation order, page 40.
What do you mean accommodation order? Accommodation order.
Page 40, my lordship.
Please clarify what is accommodation order.
Lordship, my appointment, there are several appointments in the state of Assam. Those appointments were considered to be irregular.
And illegal.
Illegal. my lordship. Thereafter, the government of Assam has brought a policy, my lordship. According to that, after that policy decision was taken, verification was done. And after verification, those irregular appointees were accommodated against different schools, my lordship. So we have been accommodated against Paschim, Ukundi, petition number 1, and petition number 2, my lordship. Petition number 1 against number 3, Fara LPS, and petition number 2 has been accommodated against Paschim to do the LP school, my lordship. So, but after this accommodation letter has been issued, my lordship, salary has not been received on the and the reasons is that, my lordship.
Please write down, heard Mr. So-and-so, learned counsel for the petitioner, who submits that the petitioners are aggrieved for non-release of their salary despite issuance of the orders dated 30/1/2022. Orders, after orders, both dated, after issuance of orders, both dated 30/1/2022.
21, my
30/1/2021, by which they have been accommodated as a teacher, assistant teacher. No, as teacher. In number 3, Dar Guapara LPS and Paschim Kukundi schools respectively, bracket annexes 6 and 7. Stop, the petitioner is also aggrieved, the petitioners are also aggrieved with the issuance of show cause to them. How many show cause? 2.
Two petitioners, my lordship.
What is the other one?
My lordship, one show cause notice on page 48 one and 553 one, my lordship.
For having failed to submit the original training pass certificate. So, according to the petitioners, they have submitted their reply to the show cause notice, but the respondents have not taken any decision till date and have deprived them of the salary. In view of above, issue notice of motion returnable by 4 weeks. Miss N. Foucault, learned standing counsel. Elementary education accepts notice on behalf of respondent numbers 1, 2, 3, 4, and 5.
1 to 5, ma'am.
Petitioner to take steps for service of notice upon respondent number 6 by the speed post within 3 days. Extra copies be furnished to learned standing counsel within 2 days. List again after 4 weeks.
SCRD is a necessary party here. They have not made the SCRD as a party. So can you?
Consider that.
Yes, ma'am.
This is item 13.
SCRD.
You heard what you said.
Yes, my lordship.
If parties required, you file
Yes,
application. I'll come back.
I'll-
Item 15.
May I please your lordship? Lordship,
Yes.
may kindly pass the matter for time being. My senior is lax in court number 9.
Okay.
16.
May I please, Your Lordship?
Yes.
Lordship, the private respondent number 6 was a teacher of the concerned college, retired on superannuation from service on 13/12/2020. Then he was made governing president of the governing body on 9/5/23. Lordship, kindly have a look at page 25, the office memorandum, Lordship. May I read, Lordship?
25.
25, page 2.
Yes.
In partial modification of the earlier OM that is OM number so and so dated 9/7/2009, the following terms and condition are added and modified regarding constituting the structure of the governing body of colleges. Henceforth, retired principal from a college shall not be considered for appointment as the president of the governing body in the same college unless a minimum of 5 years have elapsed since his/her date of retirement. Then Roman to Lordship, no faculty member either retired or in service shall be considered for appointment as a president of governing body in the same college unless a minimum of 5 years have elapsed from the date of retirement.
So,
This private respondent number 6, he was retired from service on 31/12/2020. And Lordship,
so
he was made president of the governing body on
5 years,
9/5/23.
5 years. Now it's already 5 years.
No, Lordship. 23, 9/5/23.
Where is that order?
Lordship, in a RTI reply, the college authority informed the concerned advocate of this petitioner.
Where is the order? Where is the reply, RTI reply?
RTI reply at page 29, Lordship. The next page, page 30. Point number 3, the present president of the governing body assumed his office on 9/5/2023.
Where is the question?
So, Lordship,
Where is the question posed by you to RTI? The information sought by you.
RTI at page 4, page 28, Lordship. Below down, short information. When did the present president of the governing body of Mankasar College assume his office?
Page number?
Page 28, Lordship. It
Which,
is a type
okay,
copy,
which part you're reading?
Lordship, down below, the short information. Point number 3. When did the present president of the governing body of Mankasar College assume his office? So in reply, Lordship, page 30.
That is not page 28. You're reading from page 27.
Lordship, it is a type copy. Type copy is page, Lordship.
No, you point out the correct page, whether it's typed copy or printed copy, whatever, doesn't matter.
Lordship, type copy at page 26, the relevant part is page
See,
27.
Mr. Counsel, please understand. You are saying page 28 and you're reading from page 27.
No, Lordship.
How am I supposed to understand what you're reading?
Page 28 is not legible, that's why type copy is given.
So then
Lordship.
you should tell me, come to page 27,
Lordship.
so that we can read together.
Sorry, Mal, kindly come to page 27, Lordship. Point number 3. When did the present president of a governing body of Mankasar?
And who's the present president?
Safir Rahman.
Respondent number?
6.
6.
Lordship. So, in this regards, Lordship, complaint was made before the Director, Higher Education, page 7, page 32, Lordship.
Then what happened?
Then a hearing was made on 2/2/26, Lordship, page 36. Lordship. Then no speaking or reason order passed by the.
No, what is page 36?
Page 36 is the information regarding the hearing on the complaint of the petitioner, Lordship.
Whose side of Asif Hussain?
The
Petitioner?
petitioner, Lordship.
Did you not attend the hearing?
Lordship.
You were called for hearing. Did
Lordship.
you go?
Lordship.
What happened?
Just heard the complaint. What's the ground of his complaint?
Then no decision.
No decision.
Yes.
This, the respondent was 6, appointed on 9/5/2023 lawsuit. And then this is a notice when you lawsuit.
Please write down. Mr.
I, Hassan.
I. Hassan, learned counsel for the petitioner, submits that a hearing was conducted by the principal
In the office of the deputy director.
conducted by whom?
By a deputy director, higher education, Assam.
The hearing was conducted by the Deputy Director of Higher Education, Assam on 2/2/2026 at 12 noon on the complaint submitted by the petitioner that the appointment of the respondent number 6 as the president of the governing body of the Mankachar College is in violation of the office memorandum dated 5/11/2014 issued by the Higher Education Department, by which it has been provided that unless minimum 5 years has lapsed since the retirement of the principal of a college or a faculty member, he or she would not be eligible to be appointed as the president of the governing body. Stop. However, despite the hearing which took place on 2/2/2026, since there is no outcome, petitioner is before this court. Next para. Issue notice of motion returnable by 4 weeks. Mr. S. Bhuya.
Lordship. Then the higher education, lordship, 1, 2, and 3.
Standing Counsel, Higher Education accepts notice on behalf of respondent numbers 1, 2, and 3. Petitioner to take steps for service of notice upon the respondent numbers 4, 5, and 6 by speed post within 3 days. Extra copies be furnished to Mr. Bhuya within 2 days. List again on so and so.
Obliged, Lordship. Lordship, some typographical error in page 13, I may be allowed to correct in page
Oh.
13.
What is the typographical error?
Lordship. In page 13, the annexure 9,
Page
13, Lordship. The copy of the letter of hearing dated 31/1/26, it was 28, it should be 26, Lordship.
where?
Page 13, Lordship,
The copy of the hearing letter
31/1/28, it was typical error, Lordship, 28, it should be 26, Lordship.
26, 25.
instead of 25,
Lord,
6.
26, it should be 26, Lordship.
instead of
25, it should be 26.
in 2 places. Isn't it? No, this you'll have to make an application, not like that. There's already a notification. There's already a circular saying that any typographical mistake has to be corrected by IA. That is why you should be very careful when you
Sure.
file. You may file IA. I cannot give you that direction. Yes, next.
17.
Lordship. So here the grievance of the petitioners are that, Lordship, they have been accommodated as tutor instead of teacher, Your Lordship. Lordship, despite having all the necessary qualification. Lordship may kindly come to page 66, Your Lordship. This is a letter from District Elementary Education Officer to the Director of Elementary Education, Assam, Your Lordship. May I read, Your Lordship?
Yes.
I have the honor to submit here with the proposal of newly accommodated tutors having the necessary qualification to be teacher along with necessary supporting documents as reported from concerned block elementary education officers under Nagaon and Hosai district. So these petitioners are from Nagaon district, Your Lordship. In the next page, Your Lordship, 67, serial number 3, 5, 6, 8, 10, and 11. These are the petitioners, Your Lordship. So thereafter, Lordship, may kindly come to page number 68, Your Lordship.
Serial number?
3, 5, 6, then 8, then 10 and 11, Your Lordship. Now, Lordship, may kindly come to page 68, Your Lordship. Next page. This is another letter, Lordship, from Director of Elementary Education to the Secretary of Elementary Education Department, Your Lordship. So he states that, may I read, Your Lordship? With reference to the subject cited above, I would like to state that a decision was taken in the meeting of Education Department chaired by the Honorable Chief Minister Assam held on 23/1/2022 at the State Guest House, Koinadhara, in presence of Dr. Renus Pegu, Honorable Minister of Education Assam, for upgradation of newly accommodated tutors, including illegal irregular category, which is minute in the meeting. All tutors having necessary qualification to be teachers may be upgraded after proper verification and examination. This is also applicable to the accommodated tutors under illegal irregular category. Lordship. Thereafter, the names of the petitioners were sent for verification of the necessary documents, Your Lordship. Now, in this para,
Just tell me,
Lordship.
at the outset, what were you in your initial appointment?
Initially, we were appointed as assistant teachers, Your Lordship. Thereafter, we were told that those were excess posts, but our service were not terminated. Then we continued our service without any remuneration, Your Lordship. Thereafter, on this, on 31/2021, we were accommodated tutors, Your Lordship. So we should have been appointed as teacher. That's the case. See, on earlier occasions, identically situated petitioners, person came before this honorable court, and an order was passed. That Your Lordship will find it page 97, Your Lordship, whereby the coordinate bench has directed the respondent authority to accommodate the petitioners as teachers, Your Lordship, to upgrade the petitioners, Your Lordship. That order, Your Lordship, will find it page 99, para 7, Your Lordship.
What is the difference between tutor and teacher?
Lordship, tutors are the one, Your Lordship, who lacks the necessary qualification to become the teacher, Your Lordship. But the teacher have necessary qualification as per the regulation, Your Lordship. But in this case, Your Lordship,
Apart from that, any other distinction?
I think salary will be different, Your Lordship. Pay grade will be different, Your Lordship.
As tutor, you're getting what? You're getting fixed pay or pay scale.
Yes.
You are the tutor. Why are you looking here and there? You should know.
Lordship, yeah, pay will be different, Your Lordship.
How much is your pay? Fixed pay? Is it fixed pay? Tutors are enjoying better pay, what?
No. 100K.
So that's the main thing. Your grievance is that you don't want to become tutor, you want to become teacher.
Lordship.
Why? There must be certain advantages to become a teacher.
The post again, which the appointee is accommodated as tutor is purely personal in nature and will cease to exist when and when the incumbent retires from service, Your Lordship. The appointment is to Department Finance.
Anyway, we'll issue notice, Hard Mr. Good name.
Lordship, may kindly peruse the Lordship, the order, Your Lordship.
We'll peruse the order later on, not now. Hard Mr.
P. Khatoniya, Lordship.
P. Khatoniya, Learned Counsel for the petitioners. How many of them?
6 petitioners, Your Lordship.
Petitioners who submits that the petitioners having been appointed in excess to the vacancies as teachers of LP school were adjusted as tutors. Were accommodated as tutors. So according to the petitioners, there was a proposal and recommendation that the petitioners should be accommodated as teachers and not tutors. But despite the same, they have been made tutors. So the Learned Counsel submits that the petitioners have all the requisite qualification to be appointed as teachers. And therefore, they cannot be accommodated as tutors only. Since tutors are those who do not possess the requisite qualifications. Next, well, the Learned Council also relies upon the decision of the coordinate bench of this court.
We're at page 91. That coordinate bench's order is at page 91.
Right, order dated 19/12/2025, passed in WPC number 3185 of 2024, bracket annexure 11. Next, in view of above issue notice of motion, returnable by 4 weeks. Mr. GP.
Lordship, the pay band is different, Lordship. The tutor gets fixed salary of at the rate of 10,800 euros.
That is why I asked you.
And
You should
Lordship,
be aware of that. Simply saying, I want to become teacher.
No, I said, Lordship, this is different pay band, Your Lordship. And for teacher, it's from 8,000 to 60,000 euros.
Mr. G. Pego accepts notice on behalf of all the respondents.
Yes.
Extra copies be furnished to him. List again of points. On so and so. Tenable.
All right.
18.
May I please, Your Lordship? Lordship, this petition is filed for the appointment of the matter pertains to basically appointment of teachers in lower primary and upper primary school. Why not the issue here is the UDIAS code as on 10/8/2017. So this date of 10/8/2017, it has a long history, my lord, interesting history. Earlier, the DLED was of 2 years course. Thereafter, what happened? Almost the NCT section 23 of the NCT Act, right to fair compensation and right to Free and Compulsory Education Act, RT Act, basically, my lord, that was amended. So after that amendment, my lord, it was prescribed in that amendment that within 31st of March 2019, who have not gathered the DLED course, my lord, DLED qualification, then they will have to lose their jobs. Basically, it was thereafter under the Ministry of Human Resource Department conducting through NIOS, NCT has recognized that course for 18 months. It was reduced from 2 years to 18 months. And that was, government said at that time, that was at par. Basically, for the in-service teachers who was in service in the government aided, private, unaided schools. Thereafter, now the petitioners want to engage themselves in the lower primary and upper primary teachers. But the government subsequently, there was one more occasion, Supreme Court has stated that on 10/8/2017, the person who was in service, then they will be eligible for appointment. So now this question comes, for that, the government is asking us the UDIAS code for that time, my lord. So we are saying that, yes, we are ready to give the UDIAS code, but we cannot say that on 10/8/2017 because that in that time, it was not mandatory for any school, my lord, and to have the DLED course itself. So in line of that, one more petition has been filed, my lord, at page 119, similar petitioner, my lord. So similar order may be passed, tagging with that, my lord. Page 120.
Paragraph 6, madam.
Paragraph 6, madam.
Onwards. 6 and 7, my lord, are the
Yes.
main part. Notice may go, madam.
7 is the main part.
In that 7, in paragraph 7, similarly situated petitioners have approached this honorable court. The honorable court has directed, subject to outcome, and the said aspect of the matter shall be reflected in the appointment orders that would be issued in the selected candidates. But they have published the first provisional list, but they didn't mention about that, my lord.
Where is the advertisement?
My lord,
Advertisement,
advertisement, it has page 64, my lord. There are two advertisements. One is advertisement A and B. A is for LP schools and B is for UP schools. 64 and 67, my lord.
LP, and what is the other one?
Upper primary. One is lower primary, one is upper primary.
And where is the provision which says that you should have that dice code?
My lord, it was later on, they issued a notification that we have challenged, that is at page 78. So by this notice, 19/11/2025, it was directed to the petitioner to submit the details of HSSLC and the NIOS UDIS. But for ascertaining their in-service as on 10/8/2017, we are ready to give all the credentials except this UDIS code, my lord. Because why? At that time, it was non-mandatory.
Heard, Mr. BM Deka. BM
Yes, ma'am.
Deka, learned counsel for the petitioners, who submits that petitioners have participated in the recruitment exercise pursuant to the advertisements as both dated 8/1/2025 for recruitment as assistant teacher in lower primary schools, an assistant teacher, science teacher and Hindi teacher in upper primary schools. After having completed 18 months DLED course from NIOS, stop. As per the advertisement, the petitioners are required to appear before the departmental authorities for physical document verification and to furnish documents set out in the notice dated 17/6/2025, which amongst others include the UDIS records to establish that the candidate concerned was in service as on 10/8/2017. So according to the petitioners, the said requirement is on account of the fact that 18 months DLED course conducted by the NIOS was open only for untrained teachers who were in service at the relevant point of time. Stop. That the schools did not have UDAS code at the relevant point of time, and accordingly, they are not in a position to provide the said records. Stop. The Learned Council submits that after the third round of verification, authorities are contemplating to publish a list of candidates found suitable and therefore prays for an interim order to restrain the respondents from publishing the same. The Learned Council submits that similarly situated candidates have also approached this court by filing WPC number 842 of 2026. And this court, while issuing notice of motion on 18/2/2026, had observed that appointments made pursuant to the advertisements should be subject to the outcome of the writ petition. Stop. The Learned Council therefore submits that a similar order may be passed in the instant case. Next, in view of above, issue notice of motion, returnable by 4 weeks. Mr. A. Fukan, Learned Study Council,
Respond number 1 and 2.
Elementary Education,
Elementary.
steps notice on behalf of respondent numbers 1 and 2.
1, 2, and 3.
Okay, 1, 2, and 3. Who else are there?
My lord, 4, I think NCT, my lord. I think Mr. Alam is there.
My lord, I think they will appear after issuing the notice.
And NIOS.
And NIOS also same.
Extra copies will be furnished to Mr. Fukan within 2 days. Petitioner to take steps for service of notice upon the respondent numbers 4 and 5 by speed post within 3 days. List again after 4 weeks on so and so.
Deeply obliged.
My lord, that aspect also will be observed, my lord.
Just a minute.
The aspect of the matter shall be reflected in that observation made earlier, my lord.
Just a minute. I'm not.
Oh, sorry, my lord.
List again on so and so. It is having regard to the projection made by the petitioners. It is provided herein that any appointment made pursuant to the advertisements, both dated 8/1/2025, shall be subject to the outcome of this writ.
And my lord may be tagged with that WPC. Man.
Is it so?
WPC 842.
Then don't give a date. Returnable within 4 weeks on the notice. Then you write list. Matter along with WPC number 842 of 2026.
Much obliged, my lord.
Right.
May I please? My lord, this second round of litigation. Pursuant to the earlier order, my lord, the impugned earlier order, my lord, will find at page number 84, paragraph 9, my lord. The petitioner was actually serving as my lord, accountant in the block accountant under Samagro Shiksha Abhijan Mission. Paragraph 9, my lord, page 84.
This is the second round.
It was the first round order, my lord. Now presently it is second round. Thus, considering the facts and circumstances on the records and also taking note of the submissions of learned counsel for both the parties, this court inclined to dispose of the petition by directing the respondent authority, especially to respond number 2, to dispose of the representation filed by the petitioner and such on by a reasoned order, and after giving an opportunity of being heard to the petitioner. While passing the reasoned order, the respondent number 2 shall take into account the past service rendered by the petitioner and also considering the show cause reply given by him and the period of service rendered by him after 2/5/2017, and this exercise has to be carried out within a period of 4 weeks from the date of receipt of the certified copy of this order. The petition thereafter, my lord, this impugn order has been passed, my lord, whereby the claim of the petitioner has been rejected, made in the representation has been rejected, my lord. The main contention of the petitioner is that, my lord, he is a contractual employee, admitted fact, my lord, and he has even the contractual employee, my lord, cannot be terminated, my lord, without following the due process of law, my lord. That is the thing, my lord. And in the instant case, while disposing the representation, my lord, he was just the process as per the departmental proceedings, my lord, it is not been followed.
Yes, so what is your case?
The procedure adopted, my lord, by the authorities, my lord, in disposing the representation as well as for conducting the, my lord, departmental proceedings is not as per the established procedure. Because there has to be appointed presenting officer, there has to be inquiry officer, my lord, and
What is the relief you're seeking? What is
my
the
lord,
relief?
departmental proceeding is not proper. That's why, my lord, it has to be interfered with. That is the main first relief, my lord, and the fresh consideration.
No, what did you challenge in the first writ petition?
My lord, I
What?
was not allowed to join in my service, my lord, and I was not paid my salary by the then block elementary education officer.
You were not allowed to join. Where were you?
I was.
Where did you go?
I was serving as block accountant in Shalchapra Education Block and block under the block mission coordinator.
So?
He, my lord, did not allow me to work and join. And he intentionally, my lord, refused me to join. Even if I go to this office, my lord, and do the field work, he did not, my lord, record it. And as a result, he has stopped my salary, my lord, without any proceedings, without giving me any opportunity, my lord. Without salary, I have been kept for some days, my lord, some years. And thereafter, my lord, without doing proceedings, I have been terminated. Released, my lord. My reference says it's not released. Even if the temporary employee, my lord, he cannot be.
Give me the history. What is your history?
Yes,
You are appointed as what?
I was appointed, my lord. Let us come to, my lord, page number 20.
Just tell me like that.
Yeah, I was appointed as block accountant, my lord.
Then?
In the year 2011.
Thereafter?
Thereafter, my lord, I was continuing and the my lord, Shalchapra Education Block. I took.
You took leave?
Leave, my lord, on
And you did not-
17/4/2017.
You overstayed the leave.
Yes, I because I had to go outside for the.
No, don't ask me I'm not
Yes.
asking for explanation.
Yes, yes.
I'm asking you the facts.
Yes, lordship.
You were appointed as what you call accountant.
Block accountant.
Then you took leave and did not join back. So you're not allowed to join back. And later on you have been released.
Yes, I joined back, my lord, later on, but they did not accept because it was over.
That's why.
That's it.
So that's why you came before the court. Court said that they
Representation to be considered, and in the while passing
and now they have rejected. What is the reason? What is the main reason why they've rejected?
Main reason, my lord, they have stated that I was not present. That is the reason.
You were not present, that's why you want to join back.
Yes.
If you were present, there's no question of joining back. But what is the Decision.
Decision is, my lord, my prayer for consideration which was given in the representation is rejected.
How long is the gap?
Gap, my lord, I submitted my joining report on lordship will find it's for 2/5/2017.
Okay, please write this.
It was
It's
received.
okay. And Mr. B. Prakash, the learned counsel for the writ petitioner, who submits that this is the second time the petition is before this court. To stop the first writ petition being WPC number.
WPC number, my lord.
Just a minute, don't intervene.
Yes.
Being WPC number 4278 of 2024 was disposed of by order dated 23/4/2025 by directing the petitioner to file a representation to the respondent authority concerned, and the respondent authority concerned in turn should consider the same and dispose of the representation by way of a speaking order within a time frame. Stop as directed. The petitioner had submitted his representation, but the same came to be rejected by order dated 19/6/2025. Agreed, the petition is again before this court. Next para. Petitioner was appointed as block accountant under the SSA mission. But after availing leave, he had not joined back service in time. So therefore, the respondent authority concerned did not allow him to join back into service, despite the petitioner having submitted his joining report. Mr. P. Naik, any DP is not drawn?
No, if lordship comes to page 87, lordship.
DP is not required.
DP lordship, in fact, lordship, he was a contractual employee
Oh.
and his contract expired way back in the year 2017. Lordship. Thereafter, lordship, it was not renewed. And why it was not renewed, lordship, if lordship comes to page 87.
So since the contract period is over
Yes.
and not renewed, there's no requirement of.
If it
Was
is
it-
not renewed, lordship, he is not
Okay.
in employment. Lordship.
The stand of the respondents, on the other hand, is that the petitioner was a contract appointee and the term and the period of his appointment had expired already. And that the petitioner had failed to join after availing leave. Next para, in view of above, issue notice of motion returnable by 4 weeks. Mr. P. Naik, Lanet.
Lordship, I am appearing for 2, 3, and 4. SSC.
Standing Council, SSA, accepts notice on behalf of respondent numbers 2, 3, and 4.
Okay.
Ms. Jaji Prabhu, Lanet. Standing Council, Education Department, accepts notice on behalf of respondent number 1. Notice is complete. Petitioner to serve requisite extra copies within 2 days. List again on search.
Time being 15.
Yes.
Lordship. Our institution name is Northeast Council of Allied Health Science, Your Lordship. We provide the skill to Your Lordship.
What is your case? Speak up
We
loudly.
need the NOC, Your Lordship.
You need NOC.
Lordship. From the
NOC for what?
department, Lordship. To run our institute, Lordship. Annexure 6, Your Lordship, kindly. We complete all the tasks, Your Lordship.
Page?
Kindly is 35 Annexure 8, Your Lordship. This is letter issued by the Director of Medical Education to the Commissioner and Secretary, Your Lordship. Actually, Annexure 6, 7, 8 connected, Your Lordship.
What is your case? Tell me. I'm not following.
Lordship, only direction as per Annexure 8, your Lordship, to issue the NSC as we perform all, your Lordship. May I read, your Lordship, Annexure 8, your Lordship? A small para, your Lordship.
Mr. Gogoi,
Well, let me have the instruction, my lord.
what is his case?
Regarding, my lord, granting of NOC by the government, my lord,
For what?
for opening a particular college pertaining to medical education. It may be a pharmacy education or nursing or like ones. For that, my lord, the NOC from the government is required.
Where's the application?
That application perhaps has not been annexed.
But
But
it was,
will remember on the last occasion, my lord, senior counsel Buragoy appeared, my lord, a 2023 notification was put to challenge, where there was a policy that henceforth, my lord, all, my lord, registration for medical education will have to be under the Srimata Sangata University of Health Science. Then under that, my lord, scheme or policy, they are now seeking the, my lord, affiliation from that mostly. But there are certain procedure, my lord, they, according to them, everything has been fulfilled. But, my lord, that particular final NOC has not been given to them.
should fulfill the MSR guidelines, your Lordship, and minimum standard requirement, your Lordship. As per letter, your Lordship, Annexure 8 issued by the Director of Medical Education to the Commissioner, your Lordship.
So let me have the instruction, my lord, why it has not been.
Please write down, heard Mr. So-and-so, learned counsel for the petitioner. You're Karim,
Lordship,
AAR Karim, who submits that the petitioner is a society under the name and style of Northeast Council of Allied Health Science in Nalbari Town, registered under the Societies Registration Act.
Okay.
Stop. The petitioner society intends to establish a nursing institute at Swahid Mukunda Kakati Nursing Institute, Nalbari. To overcome the shortage of training of general nursing midwifery and auxiliary nursing cum midwifery. Stop. Accordingly, the petitioner has submitted an application to the respondent number 4 for grant of no objection certificate to establish the nursing institute. Stop. Despite the same, since the NOC has not been granted till date, petitioners before this court issue notice of motion, returnable by 4 weeks. Mr. B. Gogoi, learned standing counsel, Health and Family Welfare Department, accepts notice on behalf of respondent,
All the response.
on behalf of all the respondents. Extra copies be furnished to him within 2 days. List again after 4 weeks. Learned standing counsel shall obtain instructions by the next day as to why the NOC has not been granted to the petitioner society till date. List again on so-and-so.
My lord.
How many motions, Bob? There are 4. Okay, combine that.
Item 20.
Here, my lord, the petitioner was the head assistant of the Romia College, and he retired on 31st of March 2025. The issue here, my lord, is that there was an notification was passed at page 80, whereby the Government of Assam Finance Department had notified that the grade pay of the head assistant would be 10,300 rupees. Thereafter, my lord, the petitioner was promoted to the post of head assistant at page 89. He was at the post of head assistant, and thereafter he continued till 31st of March 2025. There are numerous letters of the government, my lord, to the of the Director of Higher Education and to the colleges, my lord, to the principals of all colleges, as an illustration at page 93, that is 16 November 2023, which shows that the post of head assistant, that the supervisory assistant should be treated as head assistant, and another at page 86. On 27 July 2020, the Joint Secretary to the Higher Education Department wrote to the Director of Higher Education at page 86, whereby it was stated that, my lord, the notification dated 25/8/17, the government has recommended, and the grade pay of the ministerial staff shall be as per the notification dated 25/8/17. Everything was fine, my lord, but suddenly what has happened, the Secretary of the Higher Education Department on 6/11/2025 at page 110, he wrote a letter to the Director of Higher Education, my lord, whereby the Director of Higher Education was asked as to whether the head assistants of all the provincialized colleges are drawing excess pay. And after that, my lord, the Director of Higher Education on 29/12/2025 at page 111, she wrote a letter to all the principals of the colleges that you recover the excess amount paid to all the head assistants of all the colleges in Assam. No hearing was taken place, and interestingly, my lord,
The excess payment has happened due to what? Wrong fixation of the pay.
they say, my lord, that there's a finance department has written a letter to them, and as regards whether wrong fixation. So they were asked, so accordingly, the Director of Higher Education wrote all the letters to the principals of all colleges. Then, my lord,
Notice, no recovery.
already, no lordship.
Already covered.
No, in respect of the item number 21, this person has retired. 21, let me see.
No, we are talking about 20.
20.
You are on 20 or 21?
No, this is 20.
So
20, my lord.
Why do you go to for 21 now?
21, they have recovered.
Oh, 20, we're
As
talking
of
about this
20,
only.
20, they have not recovered, but the leave encashment benefit has not been paid. According to the petitioner, around 8 lakhs, he is due to get a leave encashment benefit that has not been paid.
So they're
And
trying to deduct from there. How much is the amount to be recovered?
8 lakhs. 8 lakhs is, according to the petitioner, 8 lakhs he is due to get, but they have not paid anything to him.
No recovery.
Recovery, they have not mentioned anything. In this case, they have not mentioned anything. The treasury officer of Kamrup Metro at page 120, he has written a letter to all the principals of all the colleges that you abide by the letter of the secretary and also the Director of Higher Education. So, to my limited knowledge, my lord, the Kamrup Metro Treasury Officer should confine himself to the matters relating to Kamrup Metro, not to all the colleges of the state of Assam.
Yes, Mr. Okomani.
Lordship, here what happened, Lordship, may come to page 110, Lordship. Here, Lordship,
The post of supervisory assistant or supervising assistant of provincialized college of Assam was only re-designated as head assistant. Lordship, the second paragraph, may I read, Lordship? However, it is made clear that finance department had offered no objection to the correction of designation as head assistant instead of supervisory or supervising assistant of provincialized colleges of Assam, subject to no financial implication, Lordship, implying that the pay scale of the head assistant would remain the same as that of supervisory or supervising assistant even after redesignation. And Lordship may come to page 80, Lordship. Here, Lordship, the head assistant grade pay was 10,800, 10,300. But just next to that, Lordship, supervisory or supervising assistant, that grade pay was initially 8,000. And Lordship, at page 94, Lordship.
These will be examined at this
Yes.
stage. Will issue notice.
Yes, Lordship, only.
My lord, one prayer I have, my lord, that the petitioners are covered by Rule 3 of the Assam College Provincialization Rules 2010, which says, my lord, they shall be treated as same as the government colleges. And in respect of the government colleges, they have recently issued a regulation, my lord, the rules, wherein the head assistants have been given grade pay of rupees 10,300. And moreover, my lord, I am covered by judgments of the Apex Court, my lord, which says that they cannot deduct from the employees if there's no case of fraud or misrepresentation, my lord. And in this case, my lord, the petitioner was granted grade pay in the year 2021. Now in the year 2026, they are seeking to recover, my lord. I've pleaded in my petition, my lord, specific amendments have been made. That is not a case of fraud or misrepresentation, my lord. So in that case, even if it is a case of mistake, my lord, they cannot recover, my lord. The judgments, the certain judgments I want to praise, my lord.
Please write down. Art, Mr. Your S-Con.
S-Con, my lord.
Learned counsel for the petitioner, who submits that the petitioner retired as an head assistant of Rangia College. And by filing this writ petition, he has challenged the letters dated 6/11/2025, 29/12/2025, and 12/2/2026, by which recovery of excess grade pay drawn by the petitioner is contemplated. So the learned counsel submits that withdrawal of grade pay of rupees 10,300 by the petitioner was in terms of the sanction given by the finance department and subsequent governmental orders. And the same is not on account of fraud or withholding of facts on the part of the petitioner. Stop. The benefit was granted to the petitioner as far back as in the year 2021. And they cannot, and the respondents therefore cannot seek recovery of the same at this stage. So the learned counsel therefore submits that the impugned communications as mentioned here above should be set aside. Next, by in view of above, issue notice of motion returnable by 4 weeks. Mr. D. Upamanya, learned studying counsel, health.
Higher education.
Sorry, higher education, accepts notice on behalf of respondent numbers
1, 2, and 4.
1, 2, and 4.
E. Burwa on behalf of Mr. C. Burwa, correspondent number 6.
Mr. A. Barua appears on behalf of Mr. C. Barua. London Standing Counsel, AG Assam, who represents respondent numbers. Respondent number 6. What about finance?
Lordship, B. Gogoi still may be left.
Mr. B. Gogoi, Learned Standing Counsel Finance Department accepts notice on behalf of respondent numbers
3, 5, and 7.
3, 5, and 7. Anyone remaining?
The 8, I have to take steps, my lord.
Petitioner to take steps for service of notice on respondent number 8 by speed post within 3 days. Stop having regard to the projection made by the petitioner. It is hereby provided that till the respondent shall not make any recovery as contemplated through the impugned letters till the next returnable date. List again on search.
In this case, my lord, the petitioner is still serving, my lord, and they have made a deduction in this case. Facts are same, the notification is 25/8/17, and here in this case, the petitioner was granted the grade pay from 1/4/2016. The petitioner is still serving as the head assistant of
Give me that file, the previous one.
B. Porua College.
Date of communications are same.
The impure order is the same, my lord.
I see.
Impure orders are the same, my lord. So similar order, my lord.
He was working as what?
In this case, my lord,
He
item
is
21
working as?
in this case, item 21, he is the head assistant of B. Porua College, my lord. And his service is till April 2026, my lord.
Okay, heard,
They-
Mr.
Lordship, in this lordship, at least lordship, we have already recovered lordship that may not.
Recovered for 1 month, they have recovered, my lord.
Because he was it was only redesignation of the post lordship. No financial benefit was allowed lordship. So lordship, the grade pay should have been 8,700 instead of 10,300. So lordship, once he will get the relief, it will open a floodgate lordship. Everyone will get the benefit. So lordship, we have already started recovering from January lordship.
No, that is the reason why this petitioner is similarly situated to the other petitioner, my lord, because
No,
in
no.
this case, my lord, his grade pay was granted on 1/4/2016. And there is same facts, my lord, no misrepresentation, no fraud. There are letters from them granting the grade pay to the petitioner.
Okay, we'll cover,
The instruction.
no recovery till the next date.
Much obliged, my lord.
No further recovery. Heard Mr. S. Khan, Learned Counsel for the petitioner, who submits that the petitioner is currently serving as head assistant of a provincialized college, namely
B. Porua College.
B. Barwa College. And he is aggrieved by the letters dated 6/11/2025, 29/12/2025, and 12/2/2026, by which the respondents have sought to recover excess payment of grade pay drawn by the petitioner. Mr. The Learned Counsel submits that the petitioner is drawing the grade pay of rupees 10,300 since 1/4/2016 in terms of the rules and notifications issued by the state government from time to time. He submits that the said grade pay drawn by the petitioner is not on account of any misrepresentation or fraud on the part of the petitioner. And therefore, the respondents cannot seek recovery of the excess drawal amount. Next para, Mr. D. Upamanya, Learned Standing Council, Higher Education submits that the respondent authority concerned has already initiated recovery of the excess grade pay drawn by the petitioner. And that what was that annexure you were referring to?
The deduction is at page 99, 98, 99.
Page 66 here, Lordship. He is now getting, Lordship, 8,700. Great pay. Instead of earlier, Lordship, 10,300, now he is getting 8,700 from the month of January.
66.
Yes, Lordship. As supervisory assistant, Lordship, it was 8,000. Later on, Lordship, it was enhanced to 8,700. So from the month of January, Lordship, 26, he is getting 8,700 great pay.
Otherwise, he was drawing how much?
10,300.
Since when? 2016.
Lordship, is it is contended by the petitioner, Lordship, but I have not named.
Last line.
Has already initiated recovery of the excess grade drawn by the and that
And therefore, pending final disposal of the writ petition, no interim order may be passed. Next para. In view of above, issue notice of motion returnable by 4 weeks. Sadi Upamanya, the Understanding Council, Higher Education accept notice on behalf of respondent numbers
1, 2, and 4, Lordship.
1, 2, and 4.
3 and 5, Lordship.
Let's borrow. Then it's any other final accept notice on behalf of respondent numbers 3 and 5. Petitioner to serve notice to respond number 6 by registered by speed post within 3 days. Extra copies be furnished to the learned council secretary within 2 days. List the matter again on same date. See, regarding this interim, it is not that the amount is going to be recovered from you, is it?
No, they are monthly, they are going to deduct.
Monthly they're deducting.
They are deducting. This month they have deducted, my lord, 6,386, my lord. That is the reason why I pray for interim. They are deducting monthly.
Lordship, let me have the instruction into that, Lordship, then.
Now today is 27, they will cut in the by first week of March, they will deduct. I've made a statement, my lord, paragraph 20, my lord. So I pray similar order may be passed, my lord. Paragraph 20, I've made a statement.
You are getting what grade pay now?
Now
8,000?
8,700.
8,700. You've been brought down to 8,700.
earlier I was getting
10,000.
10,300. Now they reduce it to 8,700. 6,000 odd. If my lord may kindly peruse page 98, the net amount payable to me in December 99, December was 95,573. Now they are paying 89,187.
98. Page 98.
98 is for January 26. I'm getting now 89,187. And December 25, page 99, I was getting 95,573. So, and
So whether you should continue as 8,000 or 10,000,
that the court has to decide.
That is not in dispute. The court has to decide.
Now, by pray for an interim to the
No,
extent
but
that
it is also not your case that you should stick to that 10,300.
no, because the notification, I made a statement, my lord, that the gazette notification dated 25/8/17 still holds the field, and there are letters from them whereby they had said that the gazette notification has to be followed. I was getting the grade pay from 1/4/2016. 10 years they were paying me the grade pay of 10,300, and this impute orders were passed.
See, thing is that there are two things. One is that recovery. Because you say there's no fraud, misrepresentation, no recovery.
Yes.
Second thing is that sticking to that grade pay, two components. Is this a two-in-one writ petition?
So recovery.
That
because
you are also saying that you should be maintained with that 10,300,
till the final outcome of the decision.
not till. Is it your claim that this fixation of 10,300 is correct
Yes, my lord.
and they should give it to me
Yes, my lord.
in this writ
Yes, my lord.
petition?
Yes, my lord. Because
That is one part. The
Yes.
second part is regarding recovery.
recovery, because they are recovering now. So that is the reason why I pray, my lord, that till the next.
The recovery part will take care. But I'm asking you regarding the second part, whether that according to you, the grade pay fixed in the 2021,
2017, my lord.
2017
Yes.
is correct and it should be
Yes, my
maintained.
lord. Yes, my lord. So that is the reason why I prayed that.
Where is the prayer?
Yes, my lord.
Where is the prayer?
Prayer for setting aside those orders and mandamus that the deduction which was made may be refunded.
Next para, please write, having regard to the projection made by the petitioner, it is hereby directed that respondent shall not make further recovery
Lordship, let me have
from the petitioner, from the petitioner's pay. Till the next returnable date.
Lordship,
Date, what was the date fixed? 9th April.
Lordship, may I pray this matter to be fixed on 5th of March, Lordship?
9th?
I'll get instruction, Lordship. Interim may be considered on that day, Lordship. On 5th of March, Lordship. I'm just praying for 2 days.
Or 6th, my lord.
6th, Lordship.
The interim, because they made the deduction, my lord. Today is the end of the February.
Lordship, he came late, Lordship. He approached this.
No, I had made representations to them. 5th of
Lordship.
January, I made
I'm just
representations.
asking for 2
No,
days.
he's not going anywhere. The money is
No, the
there.
deduction, they will make the.
They may deduct, they may not deduct.
They may
That
deduct,
is
my
for
lord.
the
So
court to
that is
decide.
Till the.
Ultimately, this is only an interim measure. Let it come out on that date only. You get your instructions, whatever, and we'll see what is to be done.
On 6th, Lordship, 6th of March.
6th of March, you get the instruction by then?
Yes, Lordship, interim may be considered on that day.
The interim may be granted, my lord, because they will make the deductions otherwise. my lord.
Just
We'll listen on 6th, but not 6th. 6th will not be possible. So far, he will get that grade pay of 8,700, correct?
No, so that is the reason why they are deducting month by month. So that is the reason why I'm praying that they may not make further.
No. You've been brought back to 8,700, isn't it? You've been brought back to
Yes,
8,700.
so that is the reason why.
So this is what you'll be getting in the month of March, April, May,
That is the
June,
reason why
like
I'm
that.
praying, yes.
No, please listen. From April, May or March, April, May, June, you'll be getting the grade of 8,700. But while giving you that, they'll also deduct which was excess paid to you since 2016.
Excess, they cannot deduct, my lord,
Lordship,
because
that
I'm
has not
covered
been
by the
deducted.
judgments of the apex court. There has to be fraud and misrepresentation.
Lordship,
There was never.
Then you said they have deducted already.
No, deducted only for 1 month they have deducted. So they will deduct every month, they will deduct, my lord.
No, Lordship, excess has not been deducted, only the grade pay. So, Lordship, once the grade pay comes down, everything comes down, Lordship. So let me have the instruction on 6th, Lordship. 6th of March, Lordship. Already January, Lordship, it has been deducted. So, Lordship, he can wait for 2 days, Lordship, at least.
6th of March will not be possible. It's too short a time. And
9th,
9th, 10th. Huh? 9th. Interim will remain till 9th. Let's list the matter on 9th. On which date the interim
will be considered.
prayer shall be reconsidered.
March.
Reconsidered. I'm giving a stay. Don't take the money now.
March.
Yes. Yes, 9 March.
54 of the supplementary pages.
Well, please, your lordship.
Yes.
This prisoner before lordship, my lord. He was arrested in connection with CID PS case number, cyber PS case number 24. With And he was placed under suspension because of his detention in custody for more than 48 hours by order dated 9/10/2024, page 26. He is a school teacher, my lord, assistant teacher of Konapur Bodo High Secondary School, Vishwanath. Page 26 is the order of suspension, my lord.
Page?
26.
We are aggrieved by this.
Yes, my report is submitted by Superintendent Police CID that so and so has been arrested on 8/9/2024 in connection with CID cyber PS case number so and so. And pending royal or department proceeding against so and so is placed under suspension with effect from 8/9/2024 under Rule 6(1) of the Assam Service Disciplinary Rules 1964. So then thereafter, after more than 2 years, they issued so-called notice to me that is on 6/1/2026. The next are 27 page. The next are 6 page 27.
Yes, then?
Now my question is, your lordship, the law is very settled, when a government servant is placed under suspension, that's either within the period of 90 days, either they have to file charge sheet or there should be an order of extension. But in this case, more than 2 years, after 2 years, they have filed the charge sheet. Charges, the department proceeding was initiated. So called. Because in Madan Chaudhary's case, my lord, that Authorised Chaudhary's case, my lord, that is 2015-7 SSC. It is very clearly laid down, my. The provision under 167 CRPC has been also made applicable in the case of a department proceeding. So far, relating suspension is.
Yes, Mr. Ashik.
I'll take instruction. That should fix it.
Will issue notice or instructions? Notice, not Mr. Peak. P. Kataki. Learned counsel for the petitioner who submits that the petition is agreed with the order dated 9/10/2024, by which he has been placed under suspension with effect from 8/9/2024. He submits that the petitioner has been kept under prolonged suspension and that show cause notice has been issued to him along with the statement of allegation only on 6/1/2026. So he submits that the action of the respondent authorities being in violation of the established principle of law laid down by the Supreme Court in Ajay Kumar Chaudhary versus Union of India and another 2015 7 SCC 291. The impugned suspension order should be set aside. Next parent view of above, issue notice of motion returnable by 3 weeks. Mr. B. Kaushik, learned standing counsel. This is what, higher education or what?
No, no.
Secondary
Secondary
education. Accept notice on behalf of all the respondents. Extra copies will be furnished to him within 2 days. This the matter again on so and so. Learned counsel, standing counsel shall obtain instructions as to whether the suspension of the petitioner had been reconsidered or reviewed at any point of time. And if not, why? And if so, on which date? List accordingly.
Get to.
55.
Right. Also, can this matter be taken after some time? The additional AG will appear in this matter. After some time, it's unlike sir. So, appearing to some additional AG will appear.
Yes, you have any interim order?
Yes.
Interim prayer also. Vice Chancellor. Okay,
Published.
time being.
For orders, item 44 of the daily list.
Oh.
Yes,
Actually, long back an affidavit was filed by the BTC, but actually on the last occasion, there was a direction to serve as the copy. We didn't receive it actually. The copy of affidavit filed by BTC. So if copy is filed to us, then we could take instruction regarding rejoinder and all that.
Your Lordship, on the last occasion, I also prayed that 2021 petition, we have lost the file, Your Lordship. One petition copy is served upon us, but that also, Your Lordship, I am also not able to reconstruct the file, Your Lordship, to obtain instruction. So kindly one copy is served upon us, Your Lordship, to obtain the instruction.
he has given you one copy already.
No,
You have received the copy.
no.
You have not received.
At the time of filing, definitely we would have served. But since they
2021.
will serve it, Lordship, one extra copy will serve it, Lordship.
Also to lost the file. Right. 21, oh. So,
Learned counsel for the petitioner submits that he has not received a copy of the affidavit of position of respondent number 3. And therefore is not in a position to file rejoinder affidavit. Stop. Similarly, Ms. P. Das, Learned Standing Counsel, Secondary Education Department, submits that she requires a copy of the writ petition since the brief has been misplaced. Next para, considering the above, the parties concerned to hand over the copies that is required to each other and let the matter be listed again after 3 weeks. Readings be exchanged in the meantime. Yes.
Hearing for respondent 1 and 2.
You want me to record your name? No. Not necessary, no? Okay.
DPO.
Yes.
45.
In last occasion, Madam, Learned Standing Counsel Mr. Sisti was directed to obtain the instruction, and I was directed to furnish him a copy. I have furnished him. Today perhaps he is not present before this. The next week.
Due to some personal difficulty, he is not before to summon the court matter, matter. However, in this case, we have not received any up-to-date instructions, so some time maybe allowed. Any other day matter may be taken any other.
Next week, Madam, any date next week.
As prayed for on behalf of Mr. S.M.T. Chisti, Learned Counsel for the respondents. Matter stands adjourned to be listed again. 18 March.
DPO.
To enable him to take instructions in terms of the last court's order.
46.
May it please your lordship. Not in this case, we are supposed to file amended cost item. I'm taking another 2 days time for.
Yeah, as paid for, 2 days time is granted to the petitioners to file the amended cost item. List again after 2 weeks.
47 and 48.
Maybe please your lordship. This is the contempt petition, my lord. This honorable court passed the order on 31/5/23, my lord. Till that the respondent authority does not take any action, my lord. In the meantime, 2 or 3 days of a appointment already gone, my lord. Another appointment is going to fulfill within this month, my lord. Kindly see.
Page 16, my lord, is the order.
Yes, Mr. Kaushik.
May I pray for 2 weeks time for further up-to-date instruction? Because the authorities, my lord, requested the universities concerned, my lord, for furnishing the data in respect of these petitioners. But possibly grant me 2 week time to, my lord, get the up-to-date instruction. The last instruction which I've received was that. Towards compliance, my lord, our rationalization
2 weeks.
team has 2 weeks.
Yes,
In
Mr.
the
B.
meantime, my lord, appointment is going within this month, so the appointment is another, my read petition, my lord, kindly say, I have challenged this. Maybe time allow, my lord, within this, some post maybe not fill up, my lord.
That is not.
In contempt.
A
In
contempt or
contempt, we'll pass
read
interim
petition.
order like that. I don't think so, Mr. Counsel.
But the petition, repetition also, my lord. Yeah.
No, Mr. B. Kaushik, learned counsel for the respondent, submits that he needs 2 more weeks' time to complete his instructions. Stop. Mr. S. Salim, learned counsel for the petitioner.
Ansari, MH Ansari.
MH Ansari, learned counsel for the petitioner, expresses urgency in the matter. As paid for 2 weeks' time granted. List again also. 20 March.
My lord, in the meantime,
In the meantime, what?
the,
How do you pass such kind of order in a contempt?
my lord, my read petition also is pending, my lord. There is the read petition along with this. They are going to fill up this post, my lord, within a short date.
In fact, the earlier direction of this code was direction to the authorities to devise their own mechanism to rationalize the marks, and that in compliance, a team has already been constituted to look into
It
that.
is an order passed on 23, my lord. 23.
Here, my lord. And in the writ petition, my lord, the only ground of challenge is there was an order of this honorable court, and subsequent to that, there is an advertisement.
This is a challenge of which order? I mean, violation of which order?
Violation
Contempt.
of 31/5/2023.
Page?
Page 16.
Passed in which case?
Well, in the
Main.
document is taking up the contempt.
Yes.
On 16.
Page 16.
No. No, these are two different cases. Why is it clubbed together?
Well, what happened, Milord? In the contempt, Milord, the order against which a violation is being alleged, pursuant to that order, Milord, he has filed this writ petition challenging a subsequent advertisement, saying that there is an order in my favor, and now the advertise by way of this
Without
advertisement.
considering my contempt petition order, they are going to fill up.
There was no interim order passed in the first day, Milord.
I have no objection to
Let it
give
be after
time,
2 weeks, Milord.
only-
In the meantime, I can get my instruction.
This is the last appointment, my lord. As per this news, my lord. $4,500 post is going to fill up within these months, my lord.
It is going to happen. You file an application. Because that interim also was not given to you in the writ petition. Yes.
49.
Clear, my lord, towards compliance, my lord, your lordship will kindly see the last order.
Yes, compliance report.
Yes, my lord, the petitioner has submitted his consent with regard to accepting the provincialization order on 26/2, my lord. So, my lord will give me 1 week time, my lord, to get the order.
Mr.
Back, my lord, the
Mr.
petitioner
B.
has submitted his consent.
Mr. B. Kaushik, learned counsel for the respondent, submits that the petitioner has given his consent on
26/2.
On 26/2/2022. 26/2/2026. Consent for?
Consent for accepting the provincialization order in respect of the approval given as by the finance.
With effect from.
With effect from 4 to 2021.
2021.
Where's that?
Your lordship will see the last order. But the finance approved the provincialization from 4 to 2021. So it ought to have been 4/1/2021. But the principle.
1/1/2021.
Oh, sorry, 1/1/2021.
So petitioner give up one month, my lord.
1 month
Willingly
he
is
has
ready.
waived,
Yes.
my lord. Now he has given his consent to accept that order in the civil.
With effect from?
4 to 2021.
Okay. What did I say last time? For provincialization of his service with effect from 4 to 2021. And he therefore prays for a week's time to produce the formal order. Praise aloud. This again nonsense.
Earlier, my lord, petitioner is not well, my lord. He has already retired from service. So, my lord, since 2023, some earlier data. 60. I am the.
50.
Please, your worship. Well, can we see the last order? 1812, my lord. They're supposed to file the affidavit, my lord. Since 2023, in every occasion, they are taking time for 1 week, for 2 days, for 10 days. Till date, my lord, they have not submitted any affidavit in opposition in this case. My lord, can you see the minutes of the scrutiny, district scrutiny committee, my lord, at page 53.
What is your case?
Yes, my lord, petitioner was dropped from the provincialization list, my lord, though he was the first science teacher of the school. And after verification, his name was sent before the director, secondary education, my lord. Thereafter, my lord, he came to know that his name was dropped because of his certificate was not enclosed. Thereafter, my lord, as per provision, my lord, he enclosed his certificate, he paid fees, etc. And the district authority also sent the document to the director, my lord. And after, my lord, kindly see, after series of case, my lord, and he was also approached before this honorable court earlier. But scrutiny, honorable court, my lord, sent the matter to the scrutiny, district scrutiny committee. And scrutiny committee held on 26/6/2020. My lord, kindly see page 53, my lord. Clause 5, my lord, kindly see.
Affidavit is required. When are you filing? Time was taken last time, or many times. Speed us.
Instruction not received here, your lordship.
My lord, kindly see the earlier order, my lord.
Communication.
Twenty-one, 126, my lord, kindly see the order, my lord.
That is why I'm asking her.
Yes, my lord.
I have seen all the orders. That's why I'm asking her why affidavit is not filed. What is there more to see? And how many times should you ask for time, Ms. Pidas? Matter of 2023.
Copy, kiman my copy.
Copy and second copy was. Lordship, I will construct the file, your lordship.
You don't have the brief.
Don't
What
have-
happened?
Second.
What happened? You have misplaced it.
Lordship, we are not able to find it, your lordship. So, your lordship, I am just taking the second copy. Your lordship, kindly grant 3 weeks time, your lordship, we'll be filing our affidavit.
Ms. P. Das, Lotus Standing Counsel, Secondary Education Department, submits that she needs to reconstruct her brief since she has misplaced her file. Mr. Your good name? Mr. AJ Atia, learned counsel for the petitioner, on the other hand, submits that sufficient time has been granted to the respondents for filing their counter affidavit. Now, considering the prayer made by the petitioner, my response from the respondents would be required for adjudicating the matter, and therefore, for the ends of justice, further 3 weeks' time is granted to the Secondary Education Department for filing their counter affidavit. List this matter again on Sunday. Please do the needful.
Yes.
You can get a copy from him also.
Copy এটা লম্বা। এটা দিলে হবে। Anisha.
Mr. Lordship.
Yes.
Lordship, the matter is regarding non-compliance of the order dated 11/1/24. Lordship. Passed in WPC 677 in 2023, Lordship.
Lordship, I am on behalf of S. Das Lordship for respondent one. Already complied, Lordship. As is.
You're distributing compliance order. Huh?
What does it say?
What is this? Just see, let him see.
Order, I think, basically, right.
Yes, Mr. Counsel.
Your Lordship may kindly fix a day, Lordship. Let my senior review in this matter, Lordship, for the next day.
Who's your senior?
Ms. M.K. Chaudhary, Lordship.
By producing a notification dated 22/2026 issued by the Director of Higher Education, Assam, Mr. S. Bhuyan, learned counsel appearing for the respondent.
One Lordship. And,
Number one.
on behalf of S. Das, in contempt petition is on record, S. Das is there. I'm not. The contempt petition, I'm not there.
S. Bhuyan, learned counsel appearing on behalf of Mr.
S. Das
S. Das,
for respondent one.
the engaged counsel for respondent number one, submits that the order of this court has been complied with. So, your good name?
Argohan.
Mr. R. Gohain, learned counsel for the petitioner, submits that he may be given some time to examine the said notification and make his submission. In view of above, list the matter. When?
Any date, yes, my Lordship.
On 13 March.
Obliged.
The notification produced by Mr. S. Bhuya is retained on record and marked as X.
Deeply obliged.
52.
Yeah, please. Kindly see the last order.
And the secretary has passed this order, madam.
What was the direction?
Direction was, my lord, the page 18, my lord, relevant portion,
Page 18.
page 18, my lord, last two paragraph, my lord.
Just a minute. Page 18. Yes. Statutory appeal
Yes, my lord.
under section 14. Then
Yes, my lord. Then, my lord, the last paragraph may be seen, my lord. However, in the meantime, the petitioner is found to be eligible for provincialization following the provisions of the said Act, said 2017 Act. The respondent authorities in the elementary education department shall provincialize his service from the date of provincialization of the other teachers of said Anwarpar ME Institute, Rajeshwar Part 4, Katagao, Hailakandi district, giving him all such financial and other service benefits as applicable under the law, my lord.
regarding the statutory appeal, what would be the cause of action?
Worship, cause of action from I communicated this order on, my lord, page 14, my lord, 19, my lord.
No. Thing is that why should you file an appeal? For what?
For provincialization of my service, my lord, my post was dropped, my lord. Others teachers was provincialized, my lord, and my post was, my lord, not provincialized at that time, my lord.
No, I don't understand this direction. First of all, it says that you should prefer an appeal.
Yes, my lord.
Secondly, it again says that you are eligible for provincialization, provincialize.
Yes, my lord.
So what is the point of filing an appeal then?
Lordship, appeal was filed, my lord, when my service was not provincialized, my lord. And I approached this honorable court for disposal of my appeal, my lord. This honorable court, my lord, directed to dispose of my statutory appeal within 30 days, my lord.
What is the prayer in the statutory appeal?
Lordship, statutory appeal, my lord.
What is your prayer? Provincialization.
Yes, my lord, for provincialization.
But then the second last paragraph also says that you should be provincialized.
Yes, my lord. If I found, my lord, eligible, then my service may be provincialized.
No, it says, however, in the meantime, the petitioner is found.
Yes, my lord.
It doesn't say if, it says is found.
Yes, my lord. If found, my lord.
It's not if found, it says is found, IS.
Oh, yes, my lord. Yes.
This is a positive direction.
Yes, my lord.
Petition is found, regularized or provincialized.
Yes, my lord.
On the other hand, it says that you file appeal. I don't understand this. Who is appearing for the respondent?
I'm appealing.
What have you produced here? On behalf of whom? On behalf of?
On secretary, madam. The respondent number 1.
There is
You're appearing for the first time? No. Are you also appeared?
Yes, ma'am.
Then what is this order? What is this order about?
Finding findings may be seen.
In view of above, petitioner has not rendered 6 years of
Yes.
continuous service.
Yes, ma'am.
Cannot be
Based on
considered,
that,
provincialization cannot be considered and rejected. This is in compliance of the court's order dated 13/2/2023.
as per the last order, madam, they have given, they asked to publish his name in
Just a minute. What do you understand by this order? There's some typographical mistake or what? Is there any typing mistake? You have received the copy of this order?
No, my lord.
Give her, give him.
Regarding his name, some confusion was happened. That is why they have directed to publish his name in 3 daily newspapers, madam. That is why they have clearly stated in this order, madam. Due to some identity.
This is an order passed in that statutory appeal.
Yes, madam.
Where is the reference? It says representation dated 11/10/2023. Eleven, 10. So can somebody throw some light what is happening?
Lordship,
Tell us what is happening. You have filed this contempt
yes, my lord.
alleging non-compliance of the court's order dated 13/2.
Yes, my lord.
2023.
Yes, my lord.
What was the direction?
Direction was, my lord, I required to file statutory appeal, my lord.
Did you file?
Yes, my lord. Filed, my lord. In
When? When did you file?
3/3/2023, my lord. Annexure 4, my lord.
Statutory appeal is to be filed before whom?
Before secretary, my lord.
Okay.
Annexure 4, my lord.
3/3/23.
3/3/23, my lord.
Then what happened after that?
Then, my lord, then, my lord, this order was passed.
This order was passed. Correct?
Sir, already compliant.
And I may be liberty to challenge this order, my lord.
Yes, madam. You can challenge this order.
Ms. N. Fukan, learned counsel appearing for respondent. Which respondent?
So,
Appearing for the sole respondent by producing an order dated 26/2/2026. Issued by the Commissioner and Secretary to the Government of Assam. School Education Department submits that the direction of this court dated 13/2/2023, passed in WPC number 752 of 2023, has been complied with. Stop. As per the said order, it is seen that the prayer of the petitioner has been rejected. The prayer of the petitioner for provincialization of this service has been rejected. Stop. Learned counsel for the petitioner, Mr. Your name?
H.A. Lashkar.
H.A. Lashkar.
Lashkar.
Submits that petitioner may be given liberty to challenge the same. Next para, considering the above. The contempt petition stands closed. The petitioner will be at liberty to challenge the order passed by the Commission Secretary to the Government of Assam, School Education Department. By filing up the not IFSA advice. Yes. One more line. The said order dated so and so is retained in the record and marked as X for identification.
In this case, I am appearing for respondent number 1 and we will file our wakalatnama.
Oh, Vakalatnama. It is only on the Vakalatnama stage.
Not yet filed.
Huh?
Not yet filed. We will file as per
Not yet filed. It is on the filing of Vakalatnama stage. But why have you not complied with the order?
Here I haven't received instruction from one of my colleagues, Bitupon during.
What is the instruction? Instruction is meant for court. It is for you to read the instruction and explain to the court.
This is from pension department.
Huh?
Pension department.
You tell me, you must have read it or you have not read it.
My lord, I have read it from here.
I'll read it and explain it to you.
No, my lord, no,
Then-
I have read it. My only thing is that this.
What is this instruction?
Pending before the concerned branch, my lord, that is Obhavri SBI, my lord. Treasury officer has on several occasions visited the branch, my lord. They have not provided the, my lord, copy of the PPO, my lord.
What was the direction? Let's see. Page
Direction
10.
Yeah.
Is it page 10?
Pension regarding.
Page number 10.
Yeah, number 15, my lord. Oh, person, yes. Number 15, last paragraph, 16. In view of the consent of the parties and keeping in view the law laid down full bench of the court, the state respondent are directed to grant family pension to the petitioner in respect of PPO number so and so. If you shall thereafter deposit 50%. There are, my lord, two, actually earlier, my lord,
Two wives.
two wives.
Two wives, one husband.
Yeah, pension, my lord, enjoyed the second wife, then first wife preferred this writ appeal and then, my lord, as per the
Petitioner, who is the petitioner? First wife.
first wife,
And who's the petitioner here in this contempt?
first wife,
First wife.
yes.
Then what is the difficulty?
So earlier, my lord, pension was enjoyed by the second wife. That's the silence, my lord.
Here, my lord, treasury officer has to forward this two half of the PPO my lord, to the pension mandate. Then only
Treasury officer is a party?
Yes,
party.
response number 6.
6. But treasury officer is also having difficulty. Bank is not returning the two halves.
Concerned bank has not been returned.
This is the problem.
But if the petitioner approach the bank, my lord, I think some progress will be there.
Yes. Can you approach your bank?
We'll take instruction.
What is the bank?
Abhayapuri,
Abhayapuri
SBI.
SBI branch.
Abhayapuri.
State Bank of India, Abhayapuri branch.
Mr. P.K. Bora, Planet Council for
Respondent number 1 and 4.
respondent number 1 and 4. Submits that as per the instructions received by him.
Not from the represented, representing department, madam. This is from the pension department. This has been forwarded to me by Bitupon Deuri, madam. Government advocate Bitupon Deuri, not from the department which I am representing.
Who are you representing?
I am for 1 and 4, my lord. That is secretary and my lord director. Secretary, Department of School Education and Director, Secondary Education.
Okay, then right, as per the information, not instruction, information received by him. The treasury officer, Abhayapuri, is required to submit both halves of the PPO to the director of pension. Correct?
Madam.
For grant of family pension to the parties concerned. Stop. However, due to non-receipt of the both halves of the PPO from the SBI Abhayapuri, the same could not be forwarded to the Director of Pensions. Mr.
L. Deka.
L. Deka, learned counsel for the petitioner. To the submission submits that he will take instructions from his client in the matter. In view of above, list again. Date on 8 April. Can it be before that? Second of April. You talk to your clients, let them approach the SBI. Okay.
Obliged.
For admission, item 24.
None appears for the petitioner when the matter is called. Same was the case when the matter was listed on 3/2/2026. Mr. B. Kaushik, learned standing counsel.
In fact, the prayer which has been made in this repetition law, that has already been rejected by the government. Page 51.
Elementary education. Appears for the state department. It appears that the petitioner is no longer interested in the matter. Accordingly, the matter stands dismissed for default.
25.
Wait, please, Your Lordship.
Yes.
The authority, my lord, respondent authority has already, my lord, certified that the caste certificate is authentic. And regarding that, the registrar has given one letter, my lord.
Grievance of the petition has already been addressed. Last total, let's say, everything is reflected. Yes, yes.
Instructions.
In view of this order, my lord, Your Lordship may close the.
Learned counsel for the petitioner, Mr.
N. Sarkar. N. Sarkar.
N. Sarkar submits that in view of the communication dated 9/11/2020 issued by the registrar of Tezpur University accepting the caste certificate of the petitioner to be authentic, the writ petition has become infructuous. Sub Mr. S.C. Kayal, learned counsel, appears for the Tezpur University. In view of above, writ petition stands disposed of as infructuous.
Achha, oblige.
Good night.
Your Lord.
Yes.
Your Lordship, be pleased to see your Lordship's last order, order dated 5/1/2026, Lordship. After hearing Lordship at length, Lordship, this order has been issued. Huh? A provincial order to cancel. Cancel puri court set aside a gurus. It's a good name. It will have only been said. It is documented. It documented. Actually, you to set aside your move. Now, while the order was again came up on 29th of January, then after hearing the Lordship both the parties, the Honorable Court passed this order. Kindly see the order dated 29/1/2026. List the matter so and so. Mrs. D. Musahari, learned counsel for the respondent authorities to have instruction from the respondents on the submissions made by the learned counsel for the petitioner. This court observed that the provincialization of the respondent number 7 has already been set aside by this court, and the respondent authorities are required to have taken corrective steps to either recommend or reject the name of the petitioner in place of the respondent number 7. Lordship, they have not taken steps, Lordship. After time. Yeah.
So what do you mean by provincialization of respondent number 7 has already been set aside?
Yes.
By which
this
order?
Honorable Court.
By which order?
By order dated.
Because on 5/1/26.
Order dated to Lordship.
On 5/1/26, what was recorded is that respondent number 7 retired.
He retired, but prior to his retirement, this order has been issued on 28/7/2023.
What is that?
That order, Lordship, will find at page, it starts from page 69.
Cancelling the provincialization.
Yes.
Passed by whom?
Lordship, by this writ petition of 4116/2023, the petitioner has challenged the impugned order issued by the director whereby my prayer for provincialization was rejected. Now, after hearing the parties, the Honorable Court on 28/7/2023 passed this order whereby at page 71, the third paragraph from bottom, in that view of the matter, it appears that Director of Secondary Education Assam had reviewed its very order 7/1/15 on wrong premises, and accordingly same is set aside in quas. Then matter remand back to the director to reconsider a matter phrase. After going through this order, Lordship, on last two occasions, this order has been issued. Since the order is now set aside prior to his retirement, now they have to issue their effective order, whether I am entitled or not, because already his recommendation is cancelled, provisional order is also cancelled. So they have to take now the corrective steps, Lordship, in respect of the petitioner. So their last occasion, they took time to comply the order.
Mr. Kaushik?
Look, I have an instruction to pray for further 2 weeks' time.
Lordship, since 2011, the petitioner is before this honorable court, and every time he succeed, but ultimately, Lordship, don't get the fruits, Lordship.
Let him get his instructions. Last time you took time, this time he is taking time.
Last time, Lordship, I felt sick, Lordship, that's it.
Let Mr. Kaushik get instructions.
Well, Lordship, and they were made to dispose of the matter,
As
because
paid
they
for
have
by
to only
Mr.
take the
B. Kaushik.
corrective steps regarding my, even I am, Lordship, waive my the earlier right also.
Learned counsel for the
Comprehensive response. Last paragraph.
না 17 ফেব্রুয়ারি কালই রে
School Education Department. 2 weeks' time is granted to obtain instruction in the matter. List again on search.
That's why observation we had endeavor to dispose of the matter on the day 2011, 15 years already before this court, Lordship. They have
Mr.
to issue
Kaushik
the only
shall
corrective
obtain
order.
necessary instructions positively so that the matter can be disposed of on the next date. Okay.
Obliged.
31.
So you will find the order dated 7/1/26 and 4/2/2026. Repeatedly, they taken time for filing affidavit, my lord.
You will not file affidavit.
That payment of arrears salary, my lord.
Additional affidavit of position.
Years of 6 years service period, my lord. He retired after 13, he was provincialized. 2019, he retired, my lord. But 3 years.
But I'm yet to receive the complete instruction.
Lordship will find the last order. They informed the honorable court, my lord, they have received 4/2/2026, my lord.
The instruction which is received, my lord, it's not.
And
not to, মানে, answer
the
it
other hand,
in
my-
the repetition.
Other than that, affidavit is not required, my lord. On affidavit, they have filed, my lord. Yes.
Or lordship can dispose it of directing the second, the director to my lord to verify the claim and to prove.
What is the claim?
In time, giving time period, my lord.
What is your claim?
क्या sir?
What is your case?
My lord,
Prayer for arrears salary.
pay for arrears salary, my lord. 2013, he was provincialized. My lord, 2015, he was terminated, my lord. Therefore, we have filed writ petition. Their termination order has been set aside, my lord.
This is basically asking for the back basis money.
In
With interest.
2019, during,
You have quantified also.
my lord,
Am I audible? The amount is also quantified, isn't it?
Yes.
Amount is also 8,73,000. Any
yes, I filed representation, my lord.
where is that?
Page, my lord, 37, my lord. Annexure 11, page 37, my lord.
Page number 37.
My lord.
How many petitioners? Oh,
One petition per year.
but it says we,
Only 1 year.
and there are 5 signatories. One has become 5.
I mean, the original writ petition, earlier writ petition, my lord. They have filed another writ petition, my lord. 2, 3, 4, and 5. They have filed another writ petition that is pending, my lord. On same issue, my lord. They are working. They are getting present salary, my lord. Current salary they are getting, my lord.
The signatories of page 38 were the petitioners of the in the earlier joint team.
It's only filed earlier writ petition, my lord.
There's an affidavit of possession by respondent number 2 also.
Yes.
In this case. Who is respondent number 2? Director.
my lord.
So what is said there?
Simply said that a report of from the inspector has been called for verifying the attendance report.
Please come to page 57.
57, my lord, yes.
Annexure 7. This is the report.
Last para.
Paragraph 12, my lord, kindly say. Is pending before the government. Page
12.
Page 43. After the inspector's report.
Page?
Page 43, paragraph 12.
You are appearing for the department.
Department. We are awaiting the complete instruction from
Director.
both fellow, right?
Yes, 57, my lord.
That's why I prayed for 2 weeks' time to get the complete instruction.
Okay, take some more time.
My lord, if possible, can dispose of, my lord,
How?
with the direction to the directors.
Director has already
Examine.
given this proposal to the government.
Inspector has given a proposal, has given a report saying that you have been working,
Yes.
correct?
And
And
based on
director
that, the
to
proposal
that
has-
director has sent the proposal to the
the
secretary.
government. It's pending.
Government is to decide, that's all.
Let the government.
Hmm? But where's the letter by which the director has written to the government?
That's not a part of the.
That's what.
Lordship can take note of paragraph 12, my lord. of course, the paragraph.
Please write. Hard Mr. A.K. Hussain.
A.K. Azhar.
AK
Azad,
Azadi.
Azad.
Azad.
Lordship.
Heard Mr. AK Azad. This is item number
31.
AK Azad, learned counsel for the petitioner, and Mr. B. Kaushik, learned standing counsel,
Elementary education.
Elementary Education Department,
Sorry, secondary.
Secondary Education Department, and Mr. Chaudhary Chakraborty for the Accountant General, and Mr. G. Pegu, learned government senior, additional senior government advocate for respondent number 6, and Ms. R. M. Barua, SC Finance Department for respondent number 4. So despite giving several chances, the respondents have not come up with their counter affidavit. So today, once again, time has been sought for by the counsel for the respondents. So however, considering the nature of grievance projected by the petitioner and the materials which are available before this court, this court is of the considered view that the writ petition can be disposed of at this stage. Where is your earlier writ petition? Order.
Final order, my lord.
Page
Page
29.
29.
Order starts from page 31.
Next paragraph, the petitioner earlier approached this court by filing WPC number 5012 of 2015, which came to be disposed of on 24/8/2023. By setting aside the order dated 30/6/2015, by which the provincialization of the service of the petitioner was withdrawn. Stop. After that, what happened?
Pending,
Okay.
the petitioner retired, my lord.
Following
During
the
the pendency.
disposal of the writ manner, the petitioner sought for release of his area salaries. Which, according to him,
From June 2014 to February 2017.
amounts to rupees 873,061 for the period from June 2014 to February 2017. Stop. The same having not been paid to him, he has filed this instant writ petition. Stop. Next paragraph. The respondent. Okay, that being part I said, no, that they have not filed an affidavit of position. Can you find that? Out there, you just add this, except for respondent number 2. Then now continue the last thing. The respondent number 2 in the affidavit of position filed on 10/12/2025 has enclosed a copy of the letter dated 25/11/2025 written by the Inspector of Schools NDC, Nagaon, to the Director of Secondary Education, reporting the fact that the petitioner has been serving and working till the last date of his retirement, that is 31/1/2019. From the date of joining as headmaster, Borghuli High School. Stop. It is seen that a copy of the said communication has also been made to the Secretary to the Government of Assam, Department of School Education, and also to the District Commissioner, Nagaon. For information. Stop further. The respondent number 2 at paragraph number 12 of the counter affidavit has stated that pursuant to the report received from the Inspector of Schools, NDC Nagaon, the file has been placed before the government for appropriate instructions, and the same is awaited. Next para, in view of above. The writ petition is disposed of with direction to the
Respondent number 1.
respondent number 1.
1.
That is the Commissioner and Secretary to the Government of Assam, School Education, bracket Secondary Department, to consider and take into account the claim made by the petitioner, particularly in the light of the report which has already been submitted by the Inspector of Schools, NDC Nagaon, on 25/11/2025. Stop. Upon such consideration, if the petitioner is found to be entitled to receive the heiress salary as claimed by him, comma, the same shall be disbursed to him without further delay. Such an exercise shall be carried out within a period of
3 months.
2 months
2 months.
from the date of receipt of a certified copy of this order. Stop. In coming to such a decision, the respondent number 1 will be at liberty to verify and scrutinize the claim. But at any rate, shall not delay the matter for payment, having regard to the fact that the petitioner had since retired from service. When?
2019.
When did you retire?
2019, madam. 31, 1.
Do you know the date?
31, 1, 2019.
Okay, retired from service on 31/1/2019. All right.
But a direction may be issued by director, also director given matter, 1 and 2 matter. Because a director, director will release the amount, madam. It's come from government to director, and director will release the amount.
Let me include the director also.
No, at what point do we include the director? I have
After, after the
The
commissioner,
director has written to the government.
Yes, yes.
He cannot decide himself. So
once the government gives the approval, director will have to pay.
Director is the appointing authority, madam.
no, approval has been sought from the government.
Yes.
Yes, yes.
See.
Thereafter, this approval.
What was the last line?
Sent to director.
Not last line, second last line, something like that. Before, no, before that. Ah.
Secondary department to consider and pay in the income of the and this is not such consideration is found in total to see the equals and restriction to disclose to without the further months from the date of receipt of certified copy of this order, income research and solution responding number 1. One will verify and scrutinize the behavior as injury shall not delay the matter of payment and be brought to the fact that still from service on 1/9/2019.
Okay, we'll add it later on. Wherever it is to be added. Type of that first. Next.
Page 55 motion.
May it please your lordship.
Yes.
Your lordship, we are challenging the selection procedure for appointment of the Vice Chancellor of Assam Agricultural University, lordship. The advertisement had been issued on the 28th of October 2025. The advertisement is at page 33, lordship. Our challenge is that the procedure being followed is not in compliance with the UGC regulations of 2018, lordship. I have annexed the UGC regulations at page number 34 onwards, lordship. And these are required to be followed if lordship kindly sees para 1.2 at page 34.
(1.2).
Lordship.
It's at page 35.
34, lordship. Annex to 2.
One point two is where? Which one?
Of main paragraph 1 will. That is sub paragraph.
And below?
Below.
Again, paragraph starts. From back to square one. 1.
Yes, Lord. Short title and short title application and comment.
You're referring to below that short title?
Yes, lordship.
Okay, yes.
So 1.2 states that these shall apply to every university established or incorporated by or under a central act, provincial act, or a state act every institution, including a constituent or an affiliated college recognized by the commission in consultation with the university concerned under clause 1 of section 2 of the UGC Act 1956, and every institution deemed to be a university under section 3 of the said act. So being a university, the UGC regulations would apply, Lordship, herein.
What is the university?
Assam Agricultural University, Lordship.
This is the UGC regulation.
Lordship.
This should apply to every university established. Yes, then?
If your Lordship comes to the next page, there's another clause 1.2 at the top, Lordship, page
Yes.
35.
Yes.
Therein it says, every university or institution deemed to be university as the case may be, shall as soon as may be, but not later than within 6 months of the coming into force of these regulations, take effective steps for the amendment of the statutes, ordinances, or other statutory provisions governing it so as to bring the same in accordance with these regulations. So the state act and the statutes also has to be amended to bring it in consonance with this UGC regulations, Lordship. The UGC regulations provide the procedure for appointment of the vice chancellor of a university. The procedure is at page 63, Lordship, clause 7.3. May I read, Lordship?
Yes.
If your Lordship comes to 7.3, subclause 2, Lordship. The selection for the post of Vice Chancellor should be through proper identification by a panel of 3 to 5 persons by a search cum selection committee through a public notification or nomination or a talent search process or a combination thereof. The members of such search cum selection committee shall be persons of eminence in the sphere of higher education and shall not be connected in any manner with the university concerned or its colleges. While preparing the panel, the search cum selection academic excellence, so and so, Lordship. So 2 requirements are there for constitution of the search cum selection committee, that neither of the members of the committee shall be connected with the university in any manner, and secondly, they must be persons of eminence in the sphere of higher education, Lordship. Now, Lordship, initially after the advertisement, the committee had been constituted, Lordship, and there was a person who was connected with the university, being a member of the board of management of the university. And also she was an administrator and not a person of eminence in the sphere of education. So we challenged the same before this honorable court, and there was an order by this honorable court at page number 124. Your Lordship had passed this order. The effective portion is at page number 126. Mary Lord.
What is there to read? There's a representation only, that's all.
Yes, and it had to be considered, and until the consideration, your Lordship had stayed the procedure.
Okay.
We thereafter filed an.
This is the same connected case.
Lordship.
But the same petitioner.
Yes, yes.
Same
yes.
petitioner.
Yes.
So you have filed your representation.
Yes. Next
was
page,
disposed
Lordship,
of?
raising our grievances. And Lordship, the speaking order which we are impugning also is at page number 136. This is where our grievance stems from, Lordship.
136.
36.
Yes.
If your Lordship sees the consideration portion towards the end, Lordship.
Yes.
Under 2.2, Lordship, it is noted that the Assam Agricultural University Act as amended presently governs the appointment of the Vice Chancellor. UGC Regulations 2018, though persuasive, have not yet been formally adopted into the AAU Act or statutes. I will skip the rest, Lordship. I will come to page 137. The clause at the top. To address the concerns of conflict of interest, the Honorable Lok Bhavan sought nomination of an alternative representative of the state government. In compliance, the Honorable Chief Minister nominated Shri Ajay Tiwari, IAS, Additional Chief Secretary, Home and Political Department, and subsequently he has been notified by the Governor's Secretariat. So they have replaced one particular individual with another administrative individual, Lordship. The findings are at clause 3, Lordship. The appointment process initiated by AAU is in conformity with the provisions of the AAU Act as amended by the Assam Legislative Assembly. While UGC regulations 2018 provide broad guidelines, they are not binding unless formally incorporated into the university's governing statutes. The initial inclusion of the Agricultural Production Commissioner was consistent with the AAU Act. However, in view of the concerns raised and to ensure transparency and fairness in selection procedure, APC was substituted by Sri Ajay Tiwari, IS Additional Chief Secretary, Home and Political Department. The selection committee as reconstituted stands valid and duly notified. So one person was replaced, Lordship, and our grievance is with respect to inclusion of this individual now, Lordship.
Which individual?
Sri Ajay Tiwari, IS, Lordship.
Okay.
Because he may be a person of very good standing as an administrator, Lordship, but he is not a person of eminence in the sphere of higher education, Lordship, which is the mandate of the UGC regulations. And secondly, he must not be connected with the university in any manner, but this—
Is he connected?
He had earlier held the position of Director of Veterinary and Animal Husbandry. So earlier, in that ex officio position, he was a member of the Board of Management of the Assam Agricultural University, Lordship. So these two grounds, Lordship, we are aggrieved by this inclusion of this particular individual. And tomorrow, Lordship, the interview is supposed to be scheduled. Is scheduled, Lordship, and supposed to be held. So that is why I'm praying that this may be stayed, Lordship. The procedure may be stayed because if—
Which one should be stayed?
The procedure.
Selection of VC should be stayed.
Speaking order should be stayed.
No, this procedure for selection of the Vice Chancellor, because the selection committee who is monitoring the process is not in accordance with the UGC regulations of 2018, Lordship.
But he just read UGC regulations are not applied.
No, they are refusing to comply with the same, but our contention is that irrespective of their agreeing to comply or not, it applies, Lordship. And this has already been held by the Honorable Supreme Court in a series of judgments, Lordship.
No, but what is your apprehension? That
Lordship,
things will
our
not be,
apprehension is that
that the selection will not be fair and square.
Yes, Lordship, and that this—
On what basis? On what basis is the apprehension?
Lordship, our apprehension is that the selection committee, it has to be in accordance with the law, Lordship, firstly. It cannot be in violation of the UGC regulations. If selected, the selection procedure would not be valid as per law, Lordship. And
For that, you're stressing on page 64. Persons of eminence in the sphere of higher education.
Yes, Lordship.
And shall not be connected in any manner with the university concerned.
Yes. And Lordship, it is evident that the university says that we are not—
He's basically a bureaucrat. How is he concerned with your university?
No, he was earlier a person who was holding the post of Director of Veterinary and Animal Husbandry.
That also administration.
Yes, he's neither a person. He's not a person from of higher education, Lordship. He's an accomplished administrator for certainly, Your Lordship, but not a person from higher education department, Lordship. And secondly,
What about the other members? How many members are there? 3.
4, I believe, Lordship. Yes. Others we are not aggrieved with the selection of others.
Where's the composition? That's okay. So, Mr. Goswami, what do you say?
There are some judgments, if Your Lordship permits, I would rely on them.
My lord will kindly appreciate one thing, my lord. The post fell vacant last year, my lord. Petitioner was aggrieved that at that time also he was aggrieved that there was someone selected to the, sorry, my lord.
At that time, what was the grievance?
Yes, that
Again,
time
the
was
composition.
Again the composition. So that was his grievance. So he made a representation pursuant to your lordship's order. We take a call, my lord. If my lord perishes page 124, my koi lord aisa to main aapko reply dita.
124, yes.
125, my lord will come. Paragraph 3. Today he submits that the Vice Chancellor is also the Governor is also the Chancellor of the Assam Agriculture University, and he has been instructed, which is to the effect that the matter has been referred to the state government for examination and consideration. He also submits that the petitioner, in fact, has submitted a representation in this regard, and therefore the respective authorities may be given liberty to consider the same. So ultimately, my lord has passed this order in paragraph 5. Upon hearing the counsel, learned counsel for the parties, the writ petition is disposed of at a motion stage with direction to the petitioner to file a fresh representation before the secretary to the Gauhati Assam Department of Agriculture within a period of 1 week from today, and the respondent number 2, upon receipt of the same, shall consider and dispose of the representation by a speaking order within a period of 3 weeks from the date of receipt of the representation. Until the representation is disposed of as directed herein above, the respondent shall not finalize the constitution of the selection committee. Then he again represented. His basic ground was that the government nominee at that time, my lord, was connected to the management of the university. We considered that, my lord. We considered that, and we passed the speaking order that my lord finds at page 135, 136.
Which is that nominee?
Earlier was a, my lord, government nominee. That is, it was, my lord.
What was he? I mean,
he was all just my lord.
Just the position. Name doesn't matter.
Earlier,
Agricultural Production Commissioner Assam.
He was the Agricultural Production Commissioner. Now, my lord, since he has raised the objection regarding that person, my lord, we have changed that person. We have changed that person, and it has been informed to him. If my lord perishes the speaking order, my lord, page 136. Findings at page 137. It says the appointment process initiated by AEU is in conformity with the provisions of the AEU Act as amended by the Assam Legislative Assembly. While UGC Regulation 2018 provide broad guidelines, they are not binding unless formally incorporated to the university's governing statute. The initial inclusion of, this was his prayer, my lord, we have acceded to it. The initial inclusion of the Agricultural Production Commission was consistent with the AEU Act. It was consistent. Despite that, my lord, however, in view of the concern raised and to ensure transparency and fairness in selection process, APC was substituted. Agricultural Production Commissioner has been removed now, and Sri Ajoy Tiwari, IAS, Additional Chief Secretary, Home and Political Department, has been, my lord, inducted as a member now. Now again, he is aggrieved here, my lord. If now, my lord, will see his own conduct, my lord will kindly see page 32 of the writ petition, my lord. Page 32 of the writ petition. Is the affidavit filed by the petitioner?
Yes.
My lord will take note of his age, my lord. Age at about 60 years.
66.
66 years. Then my lord turns to next page, my lord. Here, my lord will see. This is the advertisement, my lord. Serial number 1, small Roman 1, shall be an eminent scholar and administrator. I'm skipping this. I'm coming to serial number 4, my lord. The Vice Chancellor shall hold office for a term of 5 years from the date he enters upon his office or until he attains the age of 70 years, whichever is earlier. Here is the catch, my lord. Any persons who have a minimum 5 years of service left on the last date of application shall be preferred. So now, my lord, though it was advertisement of 2025, so anybody who is to be selected, we prefer a person who can put in 5 years of service. He is already 64. So accordingly, my lord, this selection committee, it is not like a, my lord, regular interview. It's a search committee. Search committee proposes 3 names to the Honorable Governor, the Chancellor. The Chancellor will take a call among them. Here is a case, my lord, total 30 persons have applied. Those 30 persons have already been, my lord, scrutinized. And the university, the selection committee has shortlisted 10 out of 30. Petitioner was also a candidate. His candidature was found to be eligible. He was found to be eligible. It was his all documents were scrutinized. Then, my lord, in the candidates who have been, my lord, now selected for this interaction, petitioner has not qualified that, dear my lord.
He has
He
not,
has not been qualified. He is not a candidate now to be considered by the selection committee. Selection committee.
Why?
Has, my lord, kindly see this minutes. He has not challenged to this. He has suppressed this, my lord. If he
now, what is the process otherwise?
yes, process it will come from here. This is the minutes, my lord. This is the minute. These are the selection committee members. The meeting of the selection committee for appointment of a new vice chancellor of Assam Agriculture University was convened on 23rd January 2026 at 12 noon onwards under the chairmanship of Dr. So-and-so, Secretary, Department of Agricultural Research and Education and Director General, Indian Council of Agricultural Research, New Delhi. The chairperson formally welcomed all the esteemed members of the selection committee and gave a brief overview of the agenda terms to be discussed in the meeting. The eligibility based, just a minute, eligibility based on the basic requirement as per advertisement number so-and-so, dated so-and-so, was examined by the members of the selection committee for all the 31 candidates who had submitted the application form successfully and within the stipulated time. It was found that all the candidates were eligible in terms of the requirement published in the advertisement. Petitioner was also found to be eligible. After threadbare discussion and careful consideration of the basic requirements and the criteria metrics of evaluation as decided in the last meeting of the selection committee dated so-and-so, the members decided to shortlist the following candidates for personal interaction. These are the candidates. Petitioner's name doesn't figure here, my lord. He has been out in the shortlisting process, my lord. That he has not challenged. The committee, last paragraph, my lord, the committee decided to schedule the personal interaction session.
Thing is that, is he aware about this?
He may not be aware, my lord, but he has, my lord, happily participated in the process. My lord will kindly see the impugn order again, my lord. Impugn order, my lord, finds at page 136. My lord will kindly take note of the date, 23rd December 2025.
Impugn order.
23rd December 2025.
Yes.
And my lord, writ petition filed in February, my lord, challenging this order. He said he preferred a representation before the Honorable Prime Minister of India, my lord. Very well, my lord. He can file a representation. But if he was agreed, he could have participated. Sorry, he could have instituted a writ petition, my lord, that he has instituted now. From December, he was sitting over it, my lord. He was happy. He tried his luck. When he was not shortlisted, suddenly he has come and he wants that the process should be halted. There should be stay of the selection process. With university is running without a full-fledged VC for a year. And that was again because of the requisition instituted by the petitioner last year, my lord. Actually, his intention is not to be considered for selection of VC. Basically, intention is to get it sabotaged, my lord. Entire process should be sabotaged. Now, my lord, coming back to the constitution of the committee, my lord. He has not challenged. Why he is entitled for an interim order today when the selection is on fixed tomorrow, my lord, final interaction session, my lord. For that, he has challenged an order of 23rd December 2025. If my lord now perishes, page 63. He has said that we have no regard about the UGC guidelines. I will show, my lord, how the maximum possible amount, my lord, we have followed. Page 63 of the writ petition. He was not shortlisted because, my lord, he cannot put in 5 years of service, though he was otherwise found to be eligible.
See, in short,
My lord.
in short, with the decision taken by the meeting minutes,
My lord.
not to include him,
My lord.
things have changed now.
My lord.
Things have changed. You will have to challenge this.
Exactly. And if my lord perishes, just to regarding my lord compliance of UGC guidelines, page 63 for a moment, my lord.
A person who has not shortlisted included.
These 10 candidates are shortlisted. There will be interaction tomorrow, my lord. Then 3 names will be proposed to the Honorable Governor, my lord, the Chancellor. My lord, may kindly peruse page 63 for a moment.
No, just a minute. Regarding this paper you just gave me about the meeting minutes, there are how many? 10 names are there, isn't it?
My lord, 10 names have been now shortlisted, my lord.
After this, how this
After
this shortlisted names are again to be shortlisted further.
Yes, there will be an interaction, my lord. We call it an
With
interaction.
all of them.
All of them with these 10, there will be an interaction.
Then
out of 3 out of these 10 will be proposed to the governor. it's not, my lord, selection committee will not decide that who is the best vice chancellor. The honorable governor will take the call. For that, we will send a panel of persons, my lord. That will be three. That will be three. So out of 30, we have shortlisted 10.
Shortlisting is up till 10 only.
Up till 10. The
And
rest,
out of the 10, there will be interaction.
there will be interaction.
And
Then
again, further shortlisting to
Three.
three.
three will be shortlisted and finally
persons.
placed before honorable chancellor. my lord.
Okay. And when will that happen? Interaction?
Tomorrow, my lord.
Interaction happens tomorrow.
Tomorrow, 28.
Interaction with all of them.
With this 10 of
Of all 10 of them.
This 10.
Out of which the petition of the party.
Petitioner is already excluded in the shortlisted candidates, my lord. Because apparently, my lord, he cannot put in 5 years of service. If my lord peruses page 63 for a moment, my lord.
No, just before that, the committee decided to schedule the personal interactions
With the
this
shortlisted candidate in due course
course.
of time, which will be notified accordingly as per the decision of the committee. So this is an interaction, my lord. It's not like a normal regular job, my lord. It's a selection to the post of vice chancellor.
I understand. So, those who had applied for the post, who has not been shortlisted out of this 10,
Yes, my lord.
are they informed separately or not required?
That I don't know. They may be informed, my lord. That instruction I don't have, my lord. And there is no challenge to the Assam Agriculture and Industry Act, my lord. There may be a case for deliberations, my lord, but not at the behest of the petitioner at this stage, my lord. 23rd December 25, his representation was answered with a reason speaking order. If he remained aggrieved, he could have immediately assailed that, my lord. He waited till 2-3 days back, my lord. Now at the fag end, he has come. Tomorrow is the process. If there is any interim order, my lord, again the university will continue without any regular basis, my lord, which is happening since last 1 year, my lord. And that too, my lord, his ground is that some other, that Adhay Tiwari, additional chief secretary, is nowhere connected with the education department. Does it, my lord, prejudice his claim, my lord? Does it prejudice his claim? That no, this person is bad, this person is biased. No, he said that this Adhay Tiwari at one point of time was connected with the veterinary department. It's not a department, it's an autonomous university, my lord. If my lord peruses page 63 for a moment, it'll take hardly 2 minutes, my lord.
Yes, which one?
Yes, 7.3, vice chancellor.
Yes.
Serial number 2. The selection for the post of vice chancellor should be through proper identification by a panel of 3 to 5 persons, by a search cum selection committee, through a public notification or nomination, or a talent search process, or a combination thereof. The members of the search committee shall be persons of eminence in the sphere of higher education and shall not be connected in any manner with the university concerned or its colleges. While preparing the panel, the search committee shall give proper weightage to the academic excellence, exposure to the higher education system in the country and abroad, and adequate experience in academic and administrative governance to be given in writing, along with a panel to be submitted to the visitor chancellor. This is relevant, my lord. One member of the search committee, search cum selection committee, shall be nominated by the chairman, University Grants Commission, for selection of vice chancellor of state, private, or deemed university. Now, my lord, if we come back to the University Act, my lord, that my lord finds at page 164. This is the Assam Agriculture University Act. The mandate of the University Act was different, my lord, but to make the things in tune with the UGC regulations, what we have done, my lord, I will point out. Vice Chancellor, section 19. The Vice Chancellor shall be a whole-time officer of the university. He shall be an eminent scholar and an administrator with background of agriculture and animal husbandry and veterinary education, research and development, and with at least 10 years experience. The first Vice Chancellor after the commencement of this Act shall be appointed by the Chancellor for a period not exceeding 5 years, and on such terms and conditions as the Chancellor may determine. Subsequent Vice Chancellor, that is the regular selection, shall be appointed by the Chancellor from a panel of 3 names, submitted by a selection committee consisting of one eminent, what was the requirement, what is the requirement under the Act, my lord, is one eminent agricultural scientist or educationist nominated by the board. The Director General of Indian Council of Agricultural Research, a nominee by the state government. It was only 3. What we have done, my lord, to keep things in tune with UGC guideline, my lord, he has not annexed that. He is saying that this constitution is bad, but he has not annexed that, my lord. This was the constitution of the committee. My lord has seen. Has my lord got it, man?
Yes.
Serial number 2, my lord, because the prayer made by the petitioner, we have replaced by Ajay Tiwari, Additional Chief Secretary, Aruna Rajoria IS. She is gone. She has been replaced by Ajay Tiwari. Now, my lord will see, there are four members, my lord. Our Act says 3. One agricultural scientist, one ICR Director General, one nominee by the state government. What we have done, my lord will see, the last one. Serial number 4, Professor Narendra Kumar Taneja, right hand side, my lord, nominated by Chairman, University Grants Commission. It is not mandated under our Act, my lord. But since the UGC guideline says there should be a nominee from the UGC, so the UGC has nominated him. Our Act says 3-member committee, search committee, my lord. We have gone for 4 members. So there is a harmonious, my lord, if we harmoniously construe, my lord, the Act and the regulations, Act says 3 members, regulation says UGC, so we made it 4. And it is not the case of the petitioner that there is any, it is fraught with any malice, my lord.
The minimum is 3 as per the guidelines.
Yes.
It says 3 to 5.
As per the guidelines, our Act says 3. And our Act says who are to be there. So since the guideline also says nominee by UGC, so we have also taken nominee by the UGC. So basically we are following our Act and also following the UGC guidelines. Because our Act is not yet, it's not under challenge. Our Act says a nominee by the state government. So Ajay Tiwari has been nominated by the state government by the Honorable Chief Minister, my lord, approved by the Honorable Chancellor Governor. So if we, my lord, will kindly see the situation, the Act is under amendment, my lord, not yet amended. If we, my lord, if we absolutely comply, only comply with the UGC guidelines, my lord, somebody like petitioner will come up and they will say we are violating Agriculture Industry Act. So what we have done, we are complying with the Agriculture Industry Act as well as the UGC guidelines. Because our Act says a nominee by the state government. State government has nominated. And that is Mr. Tiwari, Ajay Tiwari. And he's a senior bureaucrat, my lord. He's an additional chief secretary of the state, my lord. He's a state government nominee. And it is not his case that this person is, my lord, biased. So, my lord, for today, my lord, what I propose, my lord, let notice go, my lord, I will respond. I will serve a copy of this minus, my lord, wherein his name is not figured. He can in the meantime challenge that also. But saying a selection process of a vice chancellor of such a, my lord, important university will serve nobody's purpose, my lord.
Yes.
Lordship, so it is admitted that they are not complying with the UGC regulations and they are saying that we'll comply with both. How can that be possible, Lordship? There can be one law, Lordship. And Article 254, on the basis of that, there have been cases earlier on this issue. The Honorable Supreme Court says that the UGC regulations will override the provisions of the State Act, Lordship. If I may submit one judgment in this regard. I'm submitting 2, Lordship. For you. Lordship 22-5 SCC 179 Gambhirthan.
Paragraph.
Lordship, para 41, 44, 49 and 50, Lordship.
This is regarding?
The appointment of a vice chancellor was set aside because it was done in compliance with the State Act, Lordship, and not in compliance with the UGC regulations. Para 41, if I may first read, Lordship,
Mm.
that despite, may I read, Lordship?
Yes.
Thus, despite the communication by the UGC dated 11/8/2014 and thereafter the communication by the HE, the Governor of Gujarat dated 30/8/2014 and even the observations made by the division bench of the High Court in SCC Online so in its judgment and order dated so in Gambhir Gadvi versus State of Gujarat reproduced herein above. It is unfortunate that even as on today, no further steps have been taken by the state government to amend the state legislation and to put the same on par with the UGC regulations. And the state and the universities thereunder have continued to make the appointments of vice chancellors just contrary to the UGC regulations, which as observed herein above are binding. Para 44, Lordship next. Thus, we find that the appointment of respondent number 4 is contrary to the UGC regulations 2018. Also, respondent 4 has been appointed as a appointed by a search committee not constituted as per the UGC regulations 2018. Moreover, respondent 4 does not fulfill the eligibility criteria as per the UGC regulations 2018, namely having 10 years of teaching work experience as a professor in the university system. As observed herein above, by adopting this and having accepted 80% of the maintenance expenditure from the central government, and when respondent 4 is paid a fixed pay of so and so, along with the special allowance of so and so per month, which is prescribed as per the scheme of 2008, the state and the universities thereunder are bound by the UGC regulations 2010, including the UGC regulations 2018. Para 49, Lordship. 49 and 50, Lordship. Therefore, when the appointment of respondent 4 is found to be contrary to the UGC regulations 2018 and the UGC regulations are having the statutory force, we are of the opinion that this is a fit case to issue a writ of quo warranto and to quash and set aside the appointment of respondent 4 as the vice chancellor of the SP University. It cannot be disputed that the UGC regulations are enacted by the UGC in exercise of powers under section 26(1)(e) and 26(1)(g) of the UGC Act 1956. Even as per the UGC Act, every rule and regulation made under the said Act shall be laid before each House of Parliament. Therefore, being a subordinate legislation, UGC regulations become part of the Act. In case of any conflict between the state legislation and the central legislation, the central legislation shall prevail by applying the rule or principle of repugnancy as enunciated in Article 254 of the Constitution, as the subject education is in the concurrent list of the 7th schedule to the Constitution. Therefore, any appointment as a vice chancellor contrary to the provisions of the UGC regulations can be said to be in violation of the statutory provisions warranting a writ of quo warranto. So admittedly, it is already admitted they are not complying with the UGC regulations in toto. Instead, they are trying a hybrid process, Lordship. So any appointment made pursuant to the selection procedure would be illegal, Lordship, and liable to challenge. I cannot contend if the AU Act is followed that the AU Act should have been followed. It has to be the UGC regulations. I have given another judgment, Lordship, Anindya Sundar, just the last para, Lordship. The Gambhir Gadvi was followed, para 63, Lordship. Para 63 says, in view of the decision in Gambhir K. Gadvi, even if the provisions of the Act allowed the appointment of the Vice Chancellor by the state government, it would be in violation of the UGC regulations. The regulations become part of the statute framed by the Parliament and will prevail. So this was done in accordance with the State Act. It was interfered with, Lordship. And the Honorable Supreme Court said that it has to be the UGC regulations. So unless state, Lordship, it would perpetuate an illegal procedure, Lordship.
Thing is that why have you come now?
Lordship, I have come to know that there is
December 23rd was the order.
Yes,
the order.
immediately on the subsequent two dates, Lordship, I approached the Honorable Prime Minister because my grievance was not redressed at the state level, Lordship.
So has it been addressed at that level?
It is still pending, Lordship. It has been remanded to the,
Why have you gone? I mean, if you've gone there, you wait for the outcome. Why
but
come here?
then this has, until the decision, I have given a reminder also because I know that it has been forwarded to the agricultural department of the state government. They have already decided, Lordship, they are not going to comply with the UGC regulations. I have given them a reminder on 10th of February after coming to know that this selection procedure would be held on the 28th of this month, Lordship. I went on 10th of February to them again. And the status of my grievance is at page number 151, Lordship.
But one thing is, in the light of what has been produced today,
Lordship.
unless that is challenged, then what would be your locus?
Lordship, even if selection is made, it would be illegal in violation because earlier also I had come before this honorable
No,
court
any
after.
selection, any legality cannot be challenged like that. No? You have to assert that you have the right to be there. You have the right to be considered.
No, it's a.
Now, rightly or wrongly, they have taken you out. If it so happened that you are amongst those 10 persons who are the contenders, that are different, that would paint a different picture. You're not amongst those 10 persons.
Lordship, even if I assume that I am not eligible and I'm not selected, and I'm a layman who is not a part of the proceeding also, Lordship, even then I can come before this honorable court in a writ of quo warranto challenging a procedure. The the Supreme Court in the case of Gadbi has reiterated.
But you have not that. You have not challenged this under a writ of quo warranto. Have you
Because
specifically?
the appointment has been made yet. I've come at an early stage, Lordship, when the procedure is still ongoing.
Madam, just to conclude, Madam, one paragraph of a judgment, Madam.
Which judgment?
This is my lord, Tasbir Singh Sodhi, my lord. Paragraph 13.1, my lord, is at internal page at bottom to page 21, my lord. Paragraph 13.1. It is therefore tried that candidates having taken part in the selection process without any demur or protest cannot challenge the same after having been declared unsuccessful. The candidates cannot approve it and reprove it at the same time. In other words, simply because the result of the selection process is not palatable to a candidate, he cannot allege that the process of interview was unfair or that there was some lacuna in the process. Therefore, we find that the writ petitioners in these cases could not have questioned before a court of law the rationale behind recasting the selection criteria, as they willingly took part in the selection process even after the selection, even after the criteria had been so recast, their candidature was not withdrawn in the light of the amended criteria. A challenge was thrown against the same only after they had been declared unsuccessful in the selection process. At this stage, the challenge ought not to have been entertained in the light of the principles of waiver and acquiescences. This court in Sadananda Hallo has noted that only exception to the rule of waiver is the existence of malafide on the part of the selection board. In the present case, we are unable to find any malafide or arbitrariness in the selection process, and therefore the said exception cannot be invoked. But it is not his case that Ajay Tiwari is fraught with malice. And he was, my lord, my instruction is that, my lord, Ajay Tiwari was Director of Commissioner Secretary Higher Education of the Government of Assam for 3 years.
No, that he has to be a person of eminence in the sphere of higher education.
We'll issue notice and selection would be subject to the outcome.
My lord.
Nothing beyond that.
That will be better.
WBC 520122. My lord said pass the order. We discuss on the KK and the university's case. When state has not adopted, it is not binding. Procedure has already decided that.
Anyway, you all present that at the appropriate time. Today it's only just for motion, so I'll issue notice.
Otherwise, the procedure already dealt with that particular duty Paskara family case also. Without this case also considered.
Okay, please write down. Pardon, Mr.
As they know.
S. Day, Learned Counsel for the petitioner. Who submits that the petitioner is aggrieved with the action of the respondents in not following the UGC guidelines for selecting and appointing the Vice Chancellor of the Assam Agriculture University. Stop referring to the UGC guidelines, more particularly clause 7.3. Bracket small Roman 2. The Learned Counsel submits that the search cum selection committee should comprise of persons of eminence in the sphere of higher education and shall not be connected in any manner with the university concerned or its colleges. So the Learned Counsel submits that in the present case, the respondents have included one Shri Ajay Tiwari, IAS and Additional Chief Secretary, Home and Political Department, Government of Assam, as one of the member for the Search and Selection Committee. Search cum Selection Committee. Stop. The nominated person is not an eminent person in the sphere of higher education, but a senior bureaucrat. Stop. He submits that the said person has otherwise served as a director of Agriculture Department,
Of veterinary and animal husbandry.
of Veterinary and Animal Husbandry Department at one point of time.
And Lordship, therefore, he was the member of the Board of Management of Assam Agricultural University.
Stop. In that capacity, he was therefore a member of the board of Assam Agriculture University. And as such, having regard to the description of clause 7.3 bracket Roman 2 of the UGC guidelines, he could not have been nominated as one of the search cum selection committee member. The Learned Counsel therefore submits that since the UGC guidelines have been ignored by the respondent authorities in the process, the selection of Vice Chancellor of the university concerned should be stayed. In support of his submission, the Learned Counsel has cited the following authorities. Number one, Gambhirdhan K. Gadvi versus State of Gujarat and others, 2022, 5 SCC 179, and State of West Bengal versus Anindya Sundar Das and others. 2022 16 SCC 318. Next para, Mr. P.N. Goswami, Learned Additional Advocate General. On the other hand, submits that the petitioner had earlier approached this court through WPC number 6440 of 2025, which was disposed of on 19/11/2025 by directing the petitioner to file a representation and the authority concerned to consider the same and to pass a speaking order within a time frame. Stop pursuant thereto, the petitioner submitted his representation and the same was disposed of by way of a speaking order dated 23/12/2025, bracket annexure 8. Concluding that the process of appointment of Vice Chancellor shall continue under the provisions of the Assam Agriculture University Act as amended and as per the reconstituted selection committee by removing one of the earlier member and replacing him by Sri Ajay Tiwari, Additional Chief Secretary, Home and Political Department, Government of Assam. Stop. He submits that although a speaking order was passed on 12 December 2025, the petitioner has not reacted upon the same and has now belatedly filed the instant writ petition in the month of February 2026. Stop. The Learned Additional Advocate General submits that as per the instructions received by him, as many as 31 candidates had submitted their application for the post in question, and the search cum selection committee in its meeting held on 23/1/2026 had shortlisted 10 candidates.
So 31.
Out of the 31 candidates. And the name of the petitioner does not find place amongst the shortlisted candidates. Stop. He submits that the university has been functioning without a vice chancellor for a long period of time.
Regular vice chancellor.
Without a vice chancellor on regular basis for a long period of time. And therefore, any disruption at this stage would not be in the interest of the university and the students. Stop. He also submits that the petitioner, knowing fully well about the composition of the search cum selection committee, did not raise the issue raised in the instant writ petition. And gladly participated in the process. Stop. However, for reasons best known to him, when the final interaction is to be done Amongst the shortlisted candidates, the petitioner has filed the instant writ petition. To stop. As such, it is clear that the petitioner has
One more.
adopted the principle of approbate and reprobate. As such, it is clear that the petitioner has only uh, as such, it is only clear that the petitioner has belatedly sought to challenge the process after taking part in the process himself. Of the same amounts to approbation and reprobation, which otherwise is not permissible in law. Stop. He therefore submits that the process of selection may not be stopped by this court. In support of his submission, the learned additional AG has cited the decision of the apex court rendered in Tajveer Singh Sodhi and others versus State of J&K and others. (2023) Live Law SC 253. Next, where in view of above, let notice of motion be issued, returnable by so and so. Give a date, 3 weeks. 6th of April. Mr. P.N. Goswami, learned additional AG, accepts notice on behalf of respondent numbers
2, 3, and 4.
2, 3, and 4. And Mr. K. Gogoi, learned CGC, accepts notice on behalf of respondent number 1.
Is this standing up?
Anyone, UGC?
See, Dr. P. Agarwal.
B. Agarwal.
P. Agarwal.
P for Punjab.
Punjab.
Doctor.
Dr. P. Agarwal.
Okay, can you serve him? Doctor. Has he come today, Mr. P. Agarwal? All right, you write petitioner to serve notice to respondent number 5 through Mr. P. Agarwal, Standing Counsel UGC. Stop. The acknowledgement of the notice be again submitted to the registry to show proof of service. Extra copies of the writ petition be furnished to the learned counsels appearing for the respondents today. Next para, having regard to the projection made and upon considering the submission so made, this court observes that the selection made to the post of Vice Chancellor, Assam Agriculture University, shall be subject to the outcome of the writ petition.
Good level. One submission I made, perhaps not required at this stage. even if he's selected, my lord, the petitioner, he cannot put in 5 years of service. He will be 70 before 5 years. Not required at this stage. That was one of my submissions.
That was your submission, but he can apply.
He can apply. He may
Even
not be
if
the
we have
most
2
preferred.
years.
He may not be the most
Like
preferred.
most preferred. It just says that preferential treatment is given to those person who has at least 5 years. But supposing there are no such preferential person, I mean, no person who, according to the search committee, is good enough.
True.
They may choose somebody who has only 2 years also.
Yes, yes.
What is there?
There is no bar. Deeply available.
I think the remaining matters, I think we'll get a date or something.